Lordship recalls a couple of days back in a cooperative matter, in a tight deadline, Lordship was pleased to grant the permission to amend the prayer with an observation to get the matter listed as soon as possible. We got it done with much difficulty. He is there. I requested him at 2. Otherwise, I'm dead. Nothing happens. Nothing remains, my Lord. Lordship may reject my prayer. That's a different issue. At least to save the space, my Lord, I got the matter listed.
And we can't permit that. We can't permit you to die. We will send you to the hospital immediately.
That's okay. At 2. At 2. Then observation is there for me, Lord.
You don't want us to.
No. Tomorrow might be another day. We have never seen tomorrow. I requested him a lot to come here to mention statement. Act obliged.
May I please your Lordship? Lordship, I beg to mention a read petition, Lordship, which was filed yesterday for 12 Lordship. Maybe taken on 12.
Give to the court master.
Lordship.
May it please, my lord.
Yes.
I beg to mention items 76 and 77 of today's list. My lord, would kindly accommodate us during the course. There is some urgency pertaining to the matter, my lord. 76 and 77. Today's supplement.
I'll try to.
Oh.
Okay.
May it please your Lordship.
Highly
I
obliged, my
beg to
lord.
mention item number 17 and 22. Lordship, my senior will argue these two matter, but today morning he suddenly fell sick. So Lordship, kindly pass over the matter for a week.
Item number
17 and 22.
okay. 1722. And the prayer made by the council for the petition. Medicine is adjourned to the list after.
My lord, 1 week.
List after a week.
Obliged.
Yes.
May I please, your lordship? My lord, I beg to mention item number 41, my lord.
Yes.
My lord, this is a case filed by myself, my lord, as a petitioner in person, my lord. Now, may I pray, my lord, this matter may, my lord, time permits to upgrade the matter at 2, my lord.
I'll try to let the
And my lord, another prayer, my lord,
the admission.
item number 68 and 69, my lord, is a connected matter, my lord, is an issue of some serious nature, my lord. Some disputes are going on regarding constitution of the managing committee of a mosque, my lord. So, my lord, may I pray that if time permits, my lord, then can be upgraded, my lord.
68, 69.
69, my lord.
I'll try to, but it appears to be
My
not
lord,
possible.
the last item, my lord,
Okay.
possible.
Okay.
Oblige, my lord.
Make please, Lordship. I am paying for correction 1. Respondent Lordship. In connection with 66 Lordship, I am paying for correction 1 line Lordship. And due to typographical error Lordship, we have taken a step, but the notice is not serving Lordship. In connection with 66 Lordship.
It will only be taken up when the matter is.
1 line. Suppose respondent number
I can't do it right now. The matter has to come to the report. Correct. Yes, Mr. Roy.
The matter has been compromised between the party. It may be taken on 21st of.
Give it to the court master. Give it to the court master.
I beg to mention, my lord, item number, my lord, 79, my lord. For orders it has come, my lord. Private respondents appeared, my lord. So, my lord, this matter needs to come, my lord, under admission column, my lord.
Service is complete.
Yes, my lord. Private respondent entered appearance from my lord S. Bonik, my lord.
Okay, I'll pass orders later. I'll have to look at the record and pass orders. I'll pass it.
My lord.
I'll record your presence.
Maybe the and my matter is some urgency there, my lord. Next week.
I know that because without the file, I'll not be able to pass an order and list for admission. But I'll do it.
My lord.
Even at the end of the day, I'll do it.
My lord, I beg to mention for listing pending cases.
Give it to the court master.
My lord.
Supplementary cause list, item number 70, delivery of orders.
We are directing you to produce the materials which form the reasons to believe. That you have to produce the record. You are fixing it after 10 days, give a date after 10 days.
19/6.
19/6.
Your Lordship, I am appearing for Union of India, respondent number 1.
Oh, okay,
Obliged.
we record your presence.
71 to 75 to be spoken to.
In fact, Mr. Saiwala.
Yes.
There is no query of the court. In the course of the day, I'll pass orders.
But. Only by the time, just the facts which I placed, but only one page number. All the.
If there's something shining in your shirt, you please correct yourself. Okay. Yes, item 1. Yes,
Now, the petitioner was awarded with the contract for the four laning of the national highway. And the petitioner procured the various earth materials, sand, and the borders from various sources. Insofar as the certain materials were procured on the basis of the permission granted.
Yeah.
By the authorities.
what is the direction sought to be made?
Well,
What is the nature of direction sought to be made?
now what we have done, not only the cost of the total materials, whatever has been used, on that the royalty has been calculated. The cost of the materials have been calculated, that has been sought to be realized, and 200% penalty is sought to be realized. Now, earlier, the petitioner was issued the notice by the Bureau of Investigation, demanding 3 crores rupees of the royalty. Earlier 12 crores were demanded. Then we give details and also for 3 crores. Thereafter, we came before this honorable court, and this honorable court directed that no coercive measures will be taken and the matter is pending. During the pendency of this application, another notice was issued, by which they demanded a sum of 15 crores this time. And when the details etc. before that, again another notice came by which 40 crores have been demanded. Earlier, 12 crores, then 3 crores, the matter is pending. Then 15 crores, then 40 crores. Now, I procured certain materials from the Arunachal Pradesh for which I have enclosed the transit passes which are there, and I paid the royalty there. Certain materials were procured on the basis of the permission granted, which you will also find. I have annexed all the documents from page 66 onwards. On that, the royalty was paid. And certain then earth materials were extracted from the river, for which there is a circular of the Government of India, which you will also find 119. We said for the purpose of National Highway 119
19.
19
Yes.
The digging of the ponds, wells, water bodies, rivers, utilization of the soil thereof for the purpose of the water conservation in the drought affected areas in the country regarding. Thereafter, you also see the Ministry of Road Transport Highways, Government of India is implementing the development programs on national highway network across the country, which interior involves a considerable amount of earthwork. Naturally, there is an ongoing movement of the earth for the embankments for the waste and edge projects. The contractors consistently meet the requirement through buying the earth from the farmers or procuring the same through mining or minor minerals as per the provisions of this one phase. On the other, many parts of the country are facing severe drought conditions and are of the possible to long-term solutions is water conservation and recharging through so and so. The matter has been examined in the ministry and it has been decided to link the requirement of soil for the construction work on national highways with the digging, deletion of the ponds, construction of so and so in drought prone areas as well as other areas of the country. Following steps may be taken in this behalf. Thereafter, you also see para 3 million page 120. Subject to the earth silt being found suitable for use in the road embankments, the construction agencies should excavate the earth as per their project requirements from such identified water bodies, areas, and no cost to the village panchayat, rural development department, water conservation department, and transport the same to their project sites for the use in the embankments. Similarly, all panchayat water bodies so and so of the same should not charge any amount for the construction agencies in the earth so and so. Now, without in the case of the petitioner, without all the amount which were payable by the advance royalty had been paid, I have annexed all these the documents. Then whatever was
Where are the documents?
you see, you find from page 66. 66 onwards, up to page 87. It will be challenge payment of the royalty, advance royalty. First page is the order, second page the challan. Then again,
Have you prepared a comparative statement about the, what you call this?
well, I have the details, that whatever was paid and
No,
whatever.
not that. My question is that, you see, when you are raising bills,
My lord.
you are, what do you call, giving bills for the earthwork. Correct. So is the amount of earth you have used tallies with the challan you have you are showing to us? Because if there is a difference, then the demand for forest royalty would be genuine. It would be correct.
My lord, there are two things. One other which are being paid by challan, you'll also find thereafter subsequently the materials which have been brought from the state of Arunachal Pradesh for which the transit passes and the royalty which was paid, that you'll also find from page 88 onwards, my lord.
Yes.
That you will also find all the challans on payment of the royalty in the state of Arunachal Pradesh. The materials were bought and the refugee transit passes are there.
The only anxiety is whether it tallies or not.
My lord,
The amount of earthwork which you have, for which you have billed,
my lord.
whether it tallies with the amount
I'll
of.
tell you, Lordship, the amount which has been demanded is for royalty, entire amount of royalty, entire work they have taken up, and on that they have calculated the royalty. Now they have also calculated the cost of the materials. They want to.
Where is that?
Well, you also to see the last demand notice.
Where?
Is 174. At 175, you'll also see the chart. Quantity, the total quantity which has been used, they have taken it. Then the royalty amount they have calculated. Then the price of the materials have been calculated. the price of the materials of the earth and value of that one.
No, correct. If you have not paid the, what you call, the forest royalty on the amount, then the cost of the earth will also be added. So what is wrong there?
You know, also see in the provisions of the section, when there is illegal mining, then the cost of the materials has to be realized. Now, here there is nothing of illegal mining. They say that on this product you have not paid the royalty. Now, there is no provision of 200% penalty in the act, in the rules. 200% penalty has been imposed, and you'll also see first the calculation was made of 12 crores. After seeing the documents, it was made 3 crores. The matter is sub judice before this honorable court. Court directed that the no coercive measures will be taken. During the pendency of the writ application, another demand notice is issued now for 15 crores. Then again after 15 crores, now 40 crores. You know, there is no basis at all. Nothing was asked for. Simply there are issue notices. And when the matter is sub judice, when the demand was 12 crores and has been reduced to 3 crores and the matter is pending, and the court directed that no coercive measures shall be taken, can the department then again issue notice of 15 crores and 40 crores? And the work was foreclosed in 2021. If your lordship looks into the section rule 64, it only says of, my lord, I've reproduced here, page number 36.
What is that?
Palu has to take up minor mineral rules, my lord. Assam minor.
Just one. Let Dr. Saraf.
I'm just taking it in the book, my
Dr. Saraf, page number.
36, my lord. At the bottom.
Yes. Minor minerals. Yes.
Any act of illegal or unauthorized mining shall be liable to the following. Now, there the, my lord, for the first time violation, the said mineral shall be liable to be seized along with the impounding of all such tools, equipments, vehicles, and things for such unauthorized operation, which may be released only upon realization of the payment of the price of the materials and so and so. The first requirement is that, my lord, any act of illegal or unauthorized mining shall be liable to the following.
Yes.
Now, the authority says that your see the observation at page 174.
Yes.
The last 4 lines below. Assam mineral rules for use of minor minerals, advance royalty is to be paid. If advance royalty is not paid, it is treated as illegally secured, sourced, and thus attracts the provisions of so and so rules and thereof liable for payment of royalty, price, materials, and fine as per section 63 and 64 of the said rules. Now, let's see section 63, rule 63. Rule 63, my lord. May I read, my lord? Have you also got it?
Just now.
My lord.
63, yes.
My lord. Any person undertaking any mining operations. My lord.
No. This is Assam rules you are reading.
Rules, my lord. Assam mineral, minor mineral concession rules. Now.
You have the Assam rules?
And I'm handing over my book, my lord. That book doesn't contain this. That was a
Yes,
It says, my lord, any person undertaking any mining extractions without a valid mineral concession, a valid criminal concession granted under the act and the rules framed under in areas shall be deemed to be indulging in illegal unauthorized mining and shall be dealt with in accordance with the provisions of so and so. So any person engaged in the illegal mining operation, now the authority is saying that advance payment of royalty, if the royalty is not paid in advance, it will treat it to illegal mining. Rule 5 says, below, advance payment of royalty, non-payment of royalty does not mean that illegal mining. They must come to conclusion that he is doing the illegal mining at private place. Washing Machine section rule 5, that is speaks of the advance payment of royalty.
okay.
So, my lord, my submission for loss is that, my lord, when the authorities earlier raised the demand of 12 crores and which was reduced to 3 crores without taking into consideration the other materials and factors and without taking into consideration the government circular, Government of India circular, and we came up before this honorable court and the matter is sub judice, and that policy measures not be taken, that order is passed. In the pendency of the writ application, my lord, without anything, a fresh notice is issued by now the forest authorities for demand of the 15 crores and subsequently then again 50 crores. Now price and 200% royalty, the penalty. I have not come across anywhere to a 200% penalty. And the price can only be when a person is doing a illegal mining. Now the authority says that non-payment of the advance royalty itself amounts to the illegal mining. Where from he is getting it? Rule 63 doesn't say so. And when the authority earlier, after taking into consideration the challans and all those things, came to finding that 3 crores was there instead of 12 crores, and that was subject matter challenge because which extracted the sand from the river also, which is after the Government of India circular, that is not liable to pay tax. Can it be made 15 crores, then 40 crores without a notice and without any information? They have not asked for any information direction from us. The documents, the papers, nothing.
But that's the, you see, I'm still at that question. If the total bill amount for earthwork is a 1,000 cubic meter. And all the challans, transit challans and the documents of earth which you can show is say 100. Then therefore, what is wrong in presuming that?
Nothing wrong, my lord. If they find out that yes, these are there, a difference it is there, which is not paid, they can levy. But what they have done, that entire contract, whatever value is there of use, that has been, royalty has been demanded. Without taking into consideration the fact that the amount on which the royalty has already been paid, the amount of the materials which has come from Arunachal Pradesh for which the transit process is there, and the materials which were extracted from the river, which are not liable to be taxed, not taken into consideration at all. It has been taken as it is, not a single paisa has been paid.
You see, but
Page 174 for a moment. First, page 122. 122 is a notice, the petitioner was put to notice. My lord is taking up 1765,
yes,
122 of the bill. Well, he was put to notice.
174? Page number?
122.
he's referring to page 122.
122. Then my lord come to 174.
That was 12 crores, no? That was the earlier.
174, my lord.
That was the earlier case. You'll also see the bottom at page 123, Bureau of Investigation. And that was subject matter of challenge before the High Court.
It's okay. Let him complete his part.
My lord, my lord.
My lord, 174 for a moment, my lord, at the bottom, my lord. It reads, my lord. Thus, so and so cubic meter of earth, so and so sand, so and so aggregates were utilized without payment. No acceptable documentary evidence that is valid transit challenge have been submitted against the said quality. As per the Assam minor mineral goods, for use of any such minor mineral, advance royalty has to be paid. If such advance royalty is not paid, the street is illegal, my lord. So, my lord, these, my lord, displays that there is an authority has applied mine. Petitioner was put to notice. He was asked to produce proof of procurement, which he failed, my lord. And there's a statute in operation, my lord. Statute in operation, my lord, which says there might not be, my lord, a clause in agreement, but there is a, my lord, since it's a contract, it is a, and also, my lord, will come to para 6 of the petition. Para 6, my lord, sees the basic foundation of this challenge is, my lord, rule 9. Petitioner is harping on
No,
rule
no,
9.
no. Mr. Gogoi, when
No.
you're showing me page 122,
My lord,
you see the in the first
120,
first box,
my lord,
you see as per information documents by the general manager,
my lord,
NHIDCL, the following calculations have been done.
my lord.
Items, these are the items,
Yes, my lord,
correct?
my lord.
The your utilization is given, it tallies with the first box.
My lord,
Now, second is the amount which you have calculated
my lord,
at page 123, third
My-
box.
my lord.
Now, page 174, how does this quantity has increased?
My lord.
How this quantity has increased?
Well, that was, my lord, project in charge, my lord, but we have our own mechanism. This is a state park, state, my lord, state forest, my lord. Also, my lord, see, they have 132 page number, my lord. Petitioner company was asked, my lord, to submit relevant documents, my lord.
That is between NHIDCL, not with you.
No, my lord, who is the authority who will assess, my lord, this minor minerals, my lord? Since the state of Assam, it is deducted, my lord, it has been used. And also, my lord, will kindly consider this, all these agreement contracts are foreclosed by the petitioner company itself, my lord. These roads were left incomplete, projects are left incomplete, and also, my lord, they have own foreclosed, my lord. And also, my lord, page 140. My lord, 147.
No, you just tell me the figures.
My lord. And that apart, my lord. My
No,
lord,
unless you tell it, I won't understand anything.
my lord.
Quantity of earth is 3,72,893 cubic meter,
My lord,
correct?
my lord. As per it was submitted.
Now,
114, 123.
NHIDCL, the quantity of consumption is 1141,316,
316, my lord.
120701,
My lord.
12826.
My lord is asking, putting question number 7, that figure, my lord.
174, 174.
768421.
Page 174, you have to justify that this is the quantity you have assessed. There must be some basis to assess it.
My lord,
See, there must be some basis to assess it.
my lord.
Where is the basis?
That figure, my lord, is correct. Some figure has been. This figure, my
You
lord,
see,
is.
you are not saying that when 15/7/22 letter
My-
at page 122 was written,
my lord.
you did not apply your mind.
My lord,
Once you applied your mind and justified it,
my,
and it is your own statement that in 22 they have left.
my lord.
So therefore, how does this quantity increase to this figure?
7,
I don't know, these figures are there at page 122, 123. How these figures have included in page 174? That is the only thing you'll have to explain.
my lord. That can be explained, my lord, if I take instructions, what has happened to this. Also, my lord, if my lord, I regards the liberty to take lordship to page number 10 again, my lord,
Then
10. But I meant the, my lord, basic edifice of this challenge, my lord. Petitioners have quoted section 9 of the MMDR Act, my lord.
yes,
Section 9, my lord. Lordship, if lordship takes up MMDR Act for a moment. So, my lord, basic challenge is page 10, section 9. But if my lord goes to section 14, my lord, of that same act.
no, you are showing it to 9. What is the relevance of 9?
9,
You
my
have to tell
lord,
me.
9,
Otherwise,
yes, my lord, 9 petitioners are harping that they are not liable for any kind of royalties because they are not mining lease holders. My lord has got it. But my lord will go to section 14. The provisions of section 5 to 13 inclusive shall not apply in respect of minor minerals. Section 14. my lord.
okay, so
And that apart, my lord,
no, what does it mean?
it means, my lord, one of the challenge of this petition, my lord, goes, my lord. One of the basic ground of the challenge, that section 9, we are not entitled to pay. That goes, my lord. Now, my lord, I'll quote a judgment.
No, if 5 to 13 doesn't apply,
Yes, sir.
how do you derive the right to levy? What do you
Now,
call
my
it?
lord, MMD has divided minerals into 2 sections. Major mineral, union list, minor minerals, my lord, state list. So we are dealing with here clay, sand, and earth. These are minor minerals, my lord. These are minor minerals, and my lord, section 15, my lord.
Yes,
Section 15, power of state government to make rules, my lord. My lord C and my lord section 23C. If in fact the rules, my lord, I have just handed over just a few minutes ago, these are made under 23, my lord.
yes.
20, my lord is holding 23.
23 is offenses by companies.
No, my lord, power of state government 23C, my lord, 23C, sub 23 subclause C, my lord, sub C. Power of state government to make rules. As regards minor minerals.
Where is your rules?
My lord, see, I have handed over, my lord. My lord,
Yes,
will see
okay.
the first page.
No. Which substantive rule you are referring to?
23C, my lord. And my lord will see now, since my question regards competence, my lord, whether we are authorized, my lord, that power we draw from 23C, and these rules have been made under 23C, my lord.
No, you'll have to, you see, you'll have to address what Dr. Saraf has said. Number one is the power to levy this penalty and to presume that the petitioner is has minded.
My lord.
Where are those provisions?
Well, see that rule 63 and 64.
Actually, does not say what is
It
that?
is the unauthorized mining, my lord.
No,
Well,
there's no presumption that he has done it.
no, my lord, since he failed to produce documents substantiating that he has brought it from a legal source. If the petitioner comes and shows that
No. You see, it's when there's a criminal liability, there can't be a presumption. There will be a substantive law which says that he is presumed to be a thief. Correct.
that finding is there in 174. He was asked to show documents.
No. Still, you see, it's a criminal proceeding. A petitioner has a right to remain silent.
Well.
But you see, merely because this pencil is found here, correct? And in the second half, it is found in the table of the courtmaster, doesn't make him a thief. There can't be a presumption of theft.
It can make him a thief, my lord, if he fails to come to plausible explanation.
No.
And in case, my lord, it's a control
Then-
mineral.
No. Then there will be a presumption that the law will presume that he has done the offense, like in POXO. There is a presumption that he has done it, and the negative burden will shift on the accused. The law will have to specifically say when a presumption shall arise.
My lord. And my lord,
So far as your what do you call claim for royalty is concerned, I can accept it. But to presume that he has done the mining, for that you'll have to show me something more.
that I have a judgment. I can show.
Where is that?
My lord, it's 2002 1 SCC. No, not 2002. Show the 2010. What, my lord, 2010, I'm sorry, 2010. It's my lord, Somdat Builders versus Union of India, my lord.
Yes, sir.
Hello?
Just a moment.
Yes.
Two thousand
2010 1 SCC, page 311.
one 11.
311, yes, sir. 311.
311.
311. my lord. Somdat Builders, my lord, Union of India.
2010 3 SCC.
10-1-1. 2010 1 SCC, page 311, my lord. 311.
Yes.
I'll come to my lord. 28. Reads, my lord.
Just a moment.
28.
Yes.
28, my lord, the learned senior counsel for the appellants also argued that the demand of royalty can be raised only against lessee or mining permit holder, and the demand raised against the appellants who are neither lessees nor permit holders is violative of 1963 rules. 29, my lord, the High Court, while dealing with the aforesaid contention, held. Now coming to the question as to whether the amount of royalty can be recovered from the petitioner who are contractors and suppliers of ordinary earth and other minerals, where of the considered opinion that the royalty is payable on excavation of any minor mineral. The liability is primarily of the person holding a mining lease or a mining permit. But if a person does not hold any mining lease or a mining permit, the liability does not cease. A person dealing in a minor mineral is required to maintain and keep documents to show that the royalty has been paid in order to ensure that due royalty on minor minerals have been paid within state of UP, madam. The state government by the 3 government orders have provided for producing copies of declaration in form MM1 and the treasury challan evidencing deposit of royalty. It cannot be said that any undue restrictions have been placed upon the right to carry on trade or business, or it is without the authority of law. 30, my lord. The 1963 rules have been framed by the government of Uttar Pradesh in exercise of its power conferred under Section 15 of 1957 Act. In fact, my lord, we are also at the same footing, my lord. These rules have been adopted. The definition of minor mineral is provided in clause E of section 3 of the 1957 Act. The rule makes provision for grant of mining lease, payment of royalty / dead rent, conditions of mining lease and permit, contraventions, offences and penalties for unauthorized mining, including consequences of non-payment of royalty, rent or other dues. Powers of the district officers and the officers of the Directorate of Geology and Mining for the purpose of assessment of royalty, collection of royalty or dead rent through contractor, appeal against order passed so and so rules, manner, and the remediable revisional state. First royalty appended to 1960 rules were amended. Rate of royalty for ordinary earth was fixed at ₹4 per cubic meter. 31. Admittedly, demand notices came to be issued to the appellants by the office of the district officer, bringing to their notice that they have extracted ordinary earth covered with the definition minor mineral without any permission or permit, and that they have also not paid royalty. The appellants were thus called upon to make payment of royalty. However, neither from the material placed before us nor from the judgment of the High Court transferred, the appellants responded to the said notices and raised the objection that demand of royalty cannot be raised against them, as they were not lessees or permit holders. In any case, if they raised such objection, they did not await decision of the authorities in this regard. And my lord, also there is also
Still, this judgment is not an authority on the point that there is a presumption of what you call illegal mining being done by him.
no,
It says merely royalty. Royalty, yes, royalty. I also said that royalty can be realized,
yes.
but why this penalty?
Penalty because he failed to show, my lord, since there's a provision for penalty under 63 and 62, my lord, there's a penalty provision. If somebody, my lord, doesn't come with, he doesn't show the source, my lord. And also, my lord, 32 is also relevant. They have a remedy, my lord. They have against this or demand notice, they can approach by the competent authority, which is the PCA, Consular Secretary of the government, my lord. And that apart, my lord, if liberty
Which is the provision for appeal?
appeal is, my lord, 68 of that rules, my lord.
16.
Chapter 13. Chapter 13, my lord, there's a power for review also, power for appeal also. And if my lord appeal is rejected, there's appeal for review.
So review is out of question.
Yes, ma'am.
Review can't be,
And then,
you
madam,
can't avail review. You can't avail review.
madam, I have another ground of challenge, madam.
Because the order 67 says it should be passed by the PCCF. This order was not by PCCF.
Madam, 67 says, may either an application from agreed party reviewed orders passed by under 68. Madam, 68.
60 is appeal. So review.
No, madam, unless otherwise provided an appeal against the order passed by any subordinate officer or subordinate officer
So that is
shall
appeal.
lie, madam, shall lie with the
That is
director of
good.
PCCF,
Please hear me.
madam.
Unless you hear me, you won't understand what I'm
I'm
saying.
sorry, madam, I was reading.
Review is only by the PCCF against his order, not for any other order. 67 does not say any other order.
68, madam.
68 is appeal.
No, 68 means, 68 is a word, madam. Any, unless otherwise provided, an appeal against an order passed by any subordinate officer.
So that is appeal, not review.
Lies with, he can go for appeal, madam.
Appeal is okay.
Appeal, you can go for appeal because it's a order passed by the DFO, madam.
Okay.
And also, madam, there's another resistance. And this more, this petition is not maintainable.
Why?
Well, this is not a statutory contract, madam. This has been challenged purely on the ground of contract or breach of contractual obligations, madam.
No, it's a demand of royalty. Contractual obligation
No,
is not under challenge.
Madam, what has happened here, madam? Madam, if goes to this volume, madam, they have annexed this, madam. Tender documents, volume 2 of this petition.
Yes,
Tender documents, madam.
yes.
It's page, madam, 204.
Yes,
There's a clause, madam, 3.1.2.
yes.
It says whether the contractor shall comply with all applicable laws and applicable permits, including renewals in the performance of the obligation under this agreement. This is, madam, in simplicity. 258, madam, page number 258.
So can I record your statement that you are bound by that agreement?
Hello?
As a state, you are bound by the agreement. Can I record your statement?
Yes, ma'am. That can be recorded. You're bound by the agreement.
Okay.
258, madam. 258 page number, clause number 19.1.2.
Then you are, then we'll not even hear you.
Hello?
Then we'll not even hear you. If you are bound by the agreement, you are not a party to the agreement. Agreement is between the NHI, DCL and the petitioner. You are a third party. You can't even be
Then
heard.
my lord will expunge that, madam.
No. Therefore, always
Yes.
take responsibility of what you are saying.
In that case, madam,
Correct.
this,
At morning at 10:30, 11, I'm not prepared to hear anything thrash we are submitting.
I'm sorry, madam.
No.
258, madam, for a moment, madam. Page number 258.
No, you look at the prayer first.
Madam.
Which prayer makes him challenge the what you call contract?
It's not liable, writ of mandamus, madam, any shall not be issued by declaring the petitioner is not put liable to pay any further forest royalty under terms and contract of the condition detail. That was the reason I was pointing out, madam, page 250.
Page
258, madam.
58. Yes,
258, madam, 19.1.2.
yes.
The contract price includes all duties, taxes, royalty and fees that may be levied in accordance with the laws and regulations in force as on the base date of the contractor's equipment, plans, materials and supplies acquired for the purpose of this agreement on the services performed under this agreement. Nothing in this agreement shall relieve the contractor from its responsibility to pay any tax, including any tax that may be levied in India on profits made by it respect of this agreement.
Yes.
That
Okay.
apart, my lord, what I am harping upon, since my lord, there is a statute in operation. Lordship is very correct. Lordship, they just need to go and show the source that I have bought it after paying requisite royalty from this source. Matter ends there, my lord.
Okay. Yes, Dr. Saab,
My name was, let me see once again, page 122.
122.
122.
Yes,
So this was the first notice issued to me. When you lossy find it, page 123 million, the total amount of which 12 crores something was demanded.
yes,
Now we lossy me see. Because this notice. Thereafter, my lord, I gave the explanations and lossy me see the order which has been passed by authorities. What? 133 million, 33.
133. Yes,
I made it note. With reference to the subject above, I am directed to inform you that an inquiry was initiated against the construction company so and so for the above mentioned project. In this regard, a notice was served on you to deposit the first royalty. Write this office letter based on the documents submitted by the deputy general manager in so and so that is the employer. Now you have submitted a prayer petition along with some additional forest royalty payment documents requesting to consider them while calculating the pending dues for the said project. It is to mention that your prayer petition has been considered by the undersigned, and based on the documents submitted by you and Deputy so and so, the pending dues have been reassessed and thereby recalculated as under. So the documents and papers were submitted, and on the basis of the documents, it was found at 134. The demand which was 12 crores was reduced to 3 crores. Now, this demand of 3 crores was subject matter of challenge before this honorable court. And you'll also see the order at page 135.
yes,
You will also see that page 137.
yes,
The last paragraph, further on the prayer interim leave, the state prayer will consider on the returnable date. However, as an interim measure, it is provided that no coercive steps shall be initiated against petitioner for recovery of the amount on the returnable date. And the amount is this one. Now, when the authorities, my lord, after examination documents papers, reduced the demand from 12 crores to 3 crores. And that demand was subject matter of challenge before this honorable court. And this honorable court having passed an interim order.
Yes.
That course, no coercive measures shall be taken. Can the authorities again, in spite of an interim order, issue a fresh notice determining the demand without taking into consideration the materials which were already considered? They say that no materials have been placed. Here, the materials were placed and that were taken into consideration by the authorities. Now, my learned friend was submitting for lordship the about notice at page 174.
Yes,
Lordship must see reference, this office letter number 31/12/2022. Now, this has been addressed not to me, to the employer,
which letter?
174.
Yes,
This letter was not addressed to me. And the reference which has been given of the letter, which you will also find at page 140. That letter was also addressed to the employer.
yes,
So to say that, my lord, the petitioner notice was issued to the petitioner, and the petitioner has not complied with and not produced the material, that is not correct. Now, below this letter, which was issued to the employer, was forwarded to us by the employer, and we submitted the reply to the employer itself at 142, giving all the details.
yes.
So to say, my lord, that the petitioner was given notice, and the petitioner not complied with the notice and not produced the document, that is not correct. In fact, no notice whatsoever was issued to the petitioner, writing the petitioner to produce materials. Whatever materials which you produced, the petitioner produced before the authorities, and the demand was reduced from 12 crores to 3 crores. When after considering the materials, my lord, the demand was reduced to 3 crores, how the authorities, without taking into consideration the material, again make it 15 crores and then 40 crores?
Okay, so just this in your prayer,
My lord,
page 56,
my lord.
you are challenging 31/12/22. Which page?
So 31/12/22 is page number 140. As well as we have challenged the page 174 also,
Just one.
my lord.
The second one is 16/3/23.
My lord. So as you also aware, when the matter is pending before the High Court in respect of the same issue and the order there, the authorities were incumbent on the authorities to place the matter before the court and seek a leave of the court. Without that, a particular order is state discovery motion can it be, that they can issue fresh notice again, leaving aside the early notice?
I have noted that. And the third one you have said in page 56,
My lord.
you are referring to communication dated 16/3/23. Again, you are given a date dated
No, that is in fact
28/7/22.
the wrong date is the mistake is that as per
No, it's okay, but
my lord.
16/3/23 is page 174.
My lord.
So this 28/7 is nothing. It is a mistake.
No, that is.
Okay, okay.
Now, my lord, one more submission from Lordship, my lord.
Yes,
That my lord, your Lordship has seen the order, it said, my lord, failure to pay the advance royalty shall be treated as the illegal mining act of Rule 63. Now, your Lordship has seen Rule 63, it nowhere says that failure to pay royalty, advance royalty will be treated as deemed to be a, my lord, illegal mining. Lordship is absolutely correct, my lord. Either the project should be there, would have been there, then my lord, in case of the failure to pay advance royalty, it shall be presumed deem that below it is the illegal mining. The provision of section 64 for the payment of the price and the penalty is only in respect of the illegal mining. And the authorities have not come to finding that the illegal mining is there. He's coming to finding only that because advance royalty was not paid, it will be illegal mining. That cannot be the as per the process there.
Okay. Let me consider and pass this. I'll pass it to the
My lord,
chambers.
my lord,
You'll get it uploaded only tomorrow.
my lord.
I'm keeping a book. We'll give it to you tomorrow.
Yes, ma'am.
And so far as the appeal was there.
And what is the second matter?
The second matter.
Oh, this is only one brief. Okay. I thought there are two files.
Item number 1 is
1 and 6, my lord, another 6 is there. Same color, same binding.
No, same color. Everything is
Color,
not
color,
same color, same
colors.
color.
Same color.
What is item 6? Same.
Item 6, the issue is that, that the land which is extracted from the same area and the leveling is done, whether that can be said to be the royalties payable or not. Now the issue has been settled by the apex court. Decision of the I placed before loss of the judgment. Is 81. Page 81, my lord.
First of all, which are the impugned letters?
My lord, I will. My lord, in fact, a letter was received and I submitted reply. I was just placing. The first notice. Page 75.
$75 is not the impugned letter.
No, and the first letter was there and 76 I submitted reply. You'll also manage it.
No, I just first I want to go through the impugned order, then I'll understand.
I will come.
I think 76 is the impugned.
$76 and €129.
76. And 129.
My lord. When I place the judgment of the apex court before the authority, the lawsuit sees that what the observations is making.
Okay, yes.
What
Which
the
page?
What the authority has done,
Which page?
I will say, what the authority has done, they have stopped the construction work. Now that you have not paid the royalties, so they stop the construction work itself. Now, you also just see, my lord, the judgment of the apex court, page 81. And I take your lordship to page 84. Para 13, the bottom.
Yes.
It is therefore clear that ordinary earth used for filling up or leveling purposes in construction of the embankments, roads, railway building is deemed to be a minor mineral loss. It is not in dispute that in the present appeals, excavation of the ordinary earth had been undertaken by the appellant either for laying foundation of the buildings or for the purpose of widening the channel to bring adequate quantity of the seawater for the purpose of cooling of the nuclear plant. You'll also may skip over and may come to para 16 below. As use can only follow extraction or excavation, it is the purpose of the excavation that has to be seen. The liability under section 4.7 for excavation of ordinary earth would therefore truly depend on the determination of the use purpose for which the excavated earth has been put to. An excavation undertaken by the foundation of building would not ordinarily carry out the intention to use the excavated earth for the purpose of filling up or leveling. A blanket determination of the liability merely because ordinary earth was dug up, therefore could not be justified. What would be required is a more precise determination of the end use of excavation earth, a finding on the correctness of the stand of the builders that the extracted earth was not used commercially, but was redeployed in the building operation. If the determination was to return a finding in favor of the claim made by the builders, obviously the notification dated would have to no application. The excavated earth would not be a species of mining minerals under section so and so of the act. Now, below thereafter, there is a Bombay High Court decisions. Proceedings to para 11.1. This is following that the Supreme Court
Just a moment.
at page 14.
Yes,
In the present case, it is clearly not in dispute that the petitioner
you're
undertaken
reading which para?
para 11.1 below at page 14, bottom of the pagination in here.
Yes,
In the present case, it is not in dispute that the petitioner undertaken excavation of the earth on the said lands for laying foundation of the buildings ready for development and construction. The construction of building is in terms of the sanctioned development permission dated so and so, read with the permission of the non-agricultural user. The respondent have also not alleged that there is a commercial exploitation of the excavated earth, minor minerals. The earth being excavated was sent outside or sold to anybody or transported by the petitioner. As held by the Supreme Court for the purpose of excavation need to be considered. Any liability under provisions of so and so for excavation of ordinary earth will truly depend on the determination of the use and purpose for which the excavated earth has been put to. An excavation undertaken to lay foundation of a building would therefore ordinarily carry the intention to use excavated earth minor for the purpose of filling up the leveling as has been done in the present case. As observed by us, in the present case, the excavated material has been used by the petitioner for the purpose of filling up and leveling, digging up of the earth is inbuilt in the cost of the building operation. The activity so undertaken therefore cannot be categorized as one of the excavation minor minerals as contemplated under the so Act. We have now considered follow the position pronounced by the Supreme Court in the case of so and so, question which has held thereafter the Supreme Court judgment again, which was I placed before lordship has been considered. Now, this in this case, it is not a case that the land was excavated and taken away from some other place for commercial purpose. No. Now, when this Supreme Court judgment was placed, the authority said that he unnecessarily is giving Supreme Court judgment and want to avoid this, and thereafter without writing all those things. My prayer that this has to be high-ended that you place a Supreme Court judgment and you say that you are placing Supreme Court judgment only for the purpose of avoiding the payment of royalty.
Where is the stay of construction?
My lord, the construction stop is that, my lord.
But in one of the letters I found, that the-
Every time, my lord.
no, in one of the letters here, I found that there's a mention that the earth was not used for that filling up any space in the building, but it was used for leveling of roads.
what was the apex court said, in this segment? The leveling of the, that was the issue of the leveling the building. That if the building foundation for that is used, is not there. Therefore, Bombay High Court will also see the leveling, etc., unless the land is taken away for some commercial purpose for sale, then only the question of the levy on the royalty will arise.
No, you got your, you got your earth from where?
Well, of the same place. The site itself. Your
Where-
Lordship, in the letter I mentioned it.
Where is that?
Well, I mentioned in the letter. Please. 79. Para 3. It was not taken away, not used there itself. Is. My lord, when my, I'm sorry,
Just,
I'm sorry. There is also another judgment, my lord, prior to that was the Bombay High Court, I will give the reference to that one also. Yeah. There also para 10, my lord.
yes.
The amendment is that the Supreme Court judgment passed in the communication, so effect of this amendment ought to have been brought.
Para.
Para 10, my lord. The earth so extracted while developing a plot of land and utilized on the same plot of land in leveling for the purpose of developing such plot, no royalty requires to be collected. Unless and until the land is taken away and sold for some other commercial purpose, royalty is not payable.
Just let me understand what you are arguing. You see, let us say that there is a, I'm giving two examples. Number one, there is a road to be made in a hill track. So there is what you call the hill from where you can take land, earth and fill it up. Second is that it's a what you call the existing road, which is to be broadened, and therefore you are taking land from the side and then you are piling it up.
Leveling it up.
Correct.
Like in the building below, piling work is
No,
done.
in a building, what you do is that in the same land, you are digging it up, laying foundation and then filling it up.
Here
But
also,
in this, in these two examples I'm giving, one where you are making road in the hilly terrain,
Right.
there you are extracting earth from the hill and you are filling it up. Correct. So will, and in the other case, the earth which is lying in the side of the road, that you are digging it up and
Lord,
leveling it in the
you're
road.
also correct. You're absolutely correct.
Correct.
You're
So
also-
that is an extra land. It's not a land which is a part of the formation.
Lord, the
It's
pro-
a,
Lord, anywhere below the leveling work is to be done.
no, no,
Now-
no.
Now, Lord,
Formation and leveling in a roads contract.
Well, you also see, it uses the foundation as well as leveling of the road also, you also see. The road also,
Where?
the judgment which I placed before also, the Bombay High Court. It says unless the land is taken away and sold for commercial purpose.
No, no, you are a contractor.
My lord,
So
Lord.
therefore you are finding earth and then you are making it a part of the formation founding. So for formation, the requirement in the works contract is that you'll have to bring earth and then do the leveling on the road. There are parameters to do the
if
road
work
construction
contract,
work.
if I bring the earth from outside, the cost will be included. If I'm not bringing the earth from outside, the earth is provided from there itself, the cost is not paid. Assuming in the worst contract, I could bring the earth from somewhere else, like in the earlier case, the earth was materials were brought from the river, the Arunachal Pradesh side and all those things. So it is payable. But in the earthwork, where the road is there, was contract is given. If the road, the materials, earth is not to be procured from outside, it is only from leveling. The amount of the cost of the earth is not given. Because there itself, the same place, it is leveling is done.
No.
And you also see, Virat, when the construction work was stopped, my
No. You see page 76.
lord,
Page 76 that says that as per the field verification report jointly conducted by the project manager of so and so and the findings submitted as per enclosure as submitted by your earlier report, the total quantity of earth
my lord,
used by Simplex Infra for construction of road
my
from
lord,
so and so is 254,749.04 square meter,
my lord.
for which they have given royalty, and for remaining quantity of it, they have collected earth from excavating the drains, etc.
So, Virat, whatever the royal earth was brought outside, I pay the royalty. It's not a case that I'm not paying the royalty at all. Wherever it is payable, I'm paying.
No, but next line you see, the forest finds
My lord,
total quantity of earth actually found to be excavated by agencies 28,200 cubic meter,
my lord.
and therefore 80 cubic is incorrect.
You also see page 79, I given the detailed reply.
79.
One, two, and three, my lord.
You have produced a copy of your bill.
My lord,
Have you produced a copy of your bill? Whether it contains what you call cost of earth brought?
not that one because the royalty has been paid, the amount has been given.
No, that's okay. But if you have not purchased earth, the question I'm trying to ask is
My lord,
that so far as the earth which you have collected from the site, is it a part of your billed amount?
the earth will not be part of the bill amount, my lord. Which I have not procured from outside and from the same source I've given, that cannot be bill amount.
Okay. Yes,
My lord,
Mr.
that this.
Another you also just one.
Ha,
minute.
ha, ha.
You know, when the my construction work etc. was stopped, I submit, they were forced to that you submit a letter. Ultimately, I submitted letter page 133 that whatever royalty is payable. Closing see page 133 below. We undertake that we should pay royalty whatever payable.
Yes,
Now, reply you will also see page 134. Second
Yes.
paragraph. Further, I am to direct you not to use such unparliamentary words and sentences in further, where you have been repeating the same time and again, and otherwise shall be invite the provisions of the law. There is no unparliamentary words. I say that whatever is payable, I will pay. And the last part you will also see, page 135. The last line after this letter. You are hereby allowed to continue the above construction work. There is no provision empowering the authorities to stop the construction work.
yes,
And writing a letter in the legal language that whatever is payable, that he says the unparliamentary words.
I don't know, maybe in parliament they don't use that word.
My lord,
I
in
don't know.
parliament, my lord, always, my lord, unparliamentary words are used, but my lord, here, using, my lord, the legal words, he says unparliamentary words.
I don't know, because you see in parliament, we have seen people boxing each other, going to the well.
Using
That
the
is something I have found.
most words which are not to be used, that is unparliamentary. Now it should be said parliamentary words. Should not be used.
Yes,
Well, that judgment my learned senior is harping upon. Well, at para 13, I find my lord, ordinary art, my lord, is used for feeling or leveling. Feeling and leveling. And
Yes.
also at para 16, my lord.
just a moment. Which one you are referring to?
Para 13, my lord, it's at page 83, my lord. Oh, no, my lord, it's page para 13.
Yes. Yes,
Yes, my lord, I got it, my para 13. So let's here, my lord, it's not used for filling or leveling. It's for purely used for construction. That is an elevation, my lord. And because my lordship got the landscape of Rangapara to Kolliapur, we are very well aware, my lord. There's, as lordship has given a very good example, there are no hills, my lord, in the vicinity. It has to be brought up from somewhere. And if, my lord, as if the what has come proposition that no, we are digging up, then, my lord, by the time roads are built, my lord, there will be huge ponds, my lord, out there. And apart from that, in the judgment, there's a notification which classifies classification. It speaks of a 2000 notification and some classification as regards use of earth. And also in para 16, there is no final determination whether how to determine the nature where earth is used. In this case, it's a clear case. Earth is used for construction. And also, I have a judgment with me. It's 2017 3 GLT.
In fact, what you also were asking me the question, you also see page 37, I'm not disturbing you. Page 37 of the definition.
Yes,
The site. Have you got it, that is part of the content. Site of the two-line project shall include the land, buildings, structures, and roadworks are described in so and so. Thereafter, also see 3, an inventory of the site, including the land, buildings, structures, and roadwork, trees, any other involved property, or attached to the site, shall be prepared jointly by the authority representing the contractor, and such inventories shall form part of the memorandum referred to in clause 8.2 of the agreement. Now, the schedule has been given in the contract agreement itself, in volume 2, page 279. The land at page 179.
279.
You also find number 2, land. The existing row, land use, agriculture land built up, agriculture residence built up, agriculture residence built up, agriculture residence and quantity, and all those things from so and so dimension. So that is all is treated to be part of the site. Now some built up, the construction is there, that has to be dismantled. Now that will also be used in the road itself. And that will not be treated to be that the minor builders have been brought and they're subject to royalty .
Yes.
Finally, madam, I hold the judgment. It's reported in 2017 3 GLT, madam.
Yes,
It says, madam, that para,
page.
it's 2017 3 GLT 478, division bench judgment, madam.
Name of the parties.
It's State of Assam versus GH Vijapura.
Yes,
I'll directly come to para 21.
yes,
Well, here, my lord, what has been laid down in view of the provisions of clause so and so, my lord, as a rule of so and so, this court is of the view that the conclusion of learner single just to effect no royalty is required to be paid for extracting art from private patta land as well as non-forest areas, man. Whereas it is hereby declared to be unsustainable, it is held that under relevant provisions of so and so rules, my lord, art being a minor mineral subject to payment royalty on is extracted even from private patta lands, man. And other lands located in non-forest areas, it also held that appropriate notification of the rate of royalty for art has been prescribed. My lord is holding that that rules, my lord, there's a schedule appended there to my lord, where it is specified the chart for royalty, my lord. And about 23, my lord, it is provided that the competent authority, the appellant state government would issue a notice within a period of 7 days to responding companies engaged in extracting art from private patta land and other non-forest land for the purpose of utilizing the same for the filling land sites by making a demand for the payment of royalty for the extracted art by stating the basis of such demand, and upon such notice being issued, the respective respondent contractors would submit their response within a period of 15 days. Thereafter, by indicating the objection to the demand, if any, and thereafter, upon considering the objection, the competent authority would pass appropriate order requiring the respondent authority to pay royalty as may be assessed. The payment of royalty shall be made within a period of 1 month from the date of the order of the competent authority. In the background of those facts, but here, my lord, a tender was floated for some works of airport, my lord, and these contractors so engaged, my lord, they extracted land from even private patta lands, my lord. The court held that even if you extract land from private patta lands, my lord, you have to pay royalty, excluding forest areas are always there, my lord. That is, my lord, all. And finally, my lord, another citation is there. I'll conclude, my lord. I'll conclude. My lord, it's 2015-7 SCC, my lord.
Yes.
15-7 SCC, page number 728. I'll fall on that again, my lord, that 226 to be evoked, my lord, public the remedy sought, my lord, should be a public law remedy, my lord, which remedy is being sought by 226 and by the petitioner is a private law remedy, my lord. And in this regard, this judgment says it starts from para 69, my lord. '69 has some subheadings, 69.1. It goes up to, my lord, continue till minus 70.11.
Yes.
69, my lord. The position does summarize the aforesaid principles that we understood in the context of the discussion that preceded, which we have pointed out about. As per this, no doubt, there's no absolute power of intendable repetition, even in contractual matters or where there's a disputed question of fact, even when the monetary claims right. At the same time, my lord, discretion lies with the High Court, which under certain circumstances, it can refuse to exercise. It also follows that under the normal following circumstances, normally the court would not exercise such a decision. Number one, the court may not examine the issue unless the action has some public law character attached to it. 69.2, whenever a particular mode of settlement of dispute is provided within the contract, the High Court will refuse to exercise its discretion on 226 of the Constitution, relegate the party to the said mode of settlement, particularly when a settlement of dispute is to be resorted to means of arbitration. If there are very serious disputed questions of facts which are of complex nature and require oral evidence for the determination. Money claims per se arising out of contractual obligations are normally not to be entered except in exceptional circumstances. Further, 70, the legal position which emerges from various judgments of this court dealing with the different situation aspects relating to contracts entered into by party, state, public authority with private persons can be summarized. At the stage of entering into a contract, a state acts purely in its executive capacity and is bound by the obligations of fairness. State in its executive capacity, even in contractual field, is under obligation to act fairly and cannot practice discrimination, even in case where question is of choice or consideration of competing claims before entering into the field of contract. Facts have to be investigated and found before the question of a violation of Article 40 of the Constitution could arise. If those facts are disputed and require assessment of evidence and correctness, of which can only be tested satisfactorily by taking detailed evidence involving examination, cross-examination witnesses, the case would not be conveniently or satisfactorily decided in proceeding of 226.
Mr. Gogoi, this matter did not take you anywhere.
Well, 70.4, man.
This citing of this case will not take you anywhere. You see, in this case, what happened was that because of some reasons which is assigned here,
Yes,
I'm not
yes.
going into it.
Yes.
The party came to the High Court
Yes, ma'am.
seeking what you call the prayer was made that the contract should be rewritten.
Ma'am.
Correct.
Ma'am.
And for that,
Yes, ma'am, it is correct.
if you know the specific relief act,
Yes, madam.
section 26 says that it will be a civil court
My lord.
where a rectification of a contract can be done under section 26.
Ma'am.
So therefore, it says the red court would not be with appropriate court. That is the sum and substance of this judgment.
Actually, I had to read the whole, but I was happy. I won't read, but
It's a
70.4,
dangerous proposition to cite something without
70.5
reading
and
it.
17.6,
It's a dangerous proposition to cite something without reading it.
70.4 then, madam.
No, how does it help you?
It helps me, madam, because there's a serious dispute.
Is Dr. Saraf here to ask for a alteration of his agreement?
No, I'm not on that, madam. Since
Then-
there's a dispute, madam, my learned senior says he brings his land from here. My DFO says, madam, it's not been dug out. There's no source. How we cannot identify from where you brought that land, madam. It will require, madam, test of determination. That was I was
Just
pointing
asking
out.
Lordship the question, whether land was determined this or not. The question is only that whether land from the same area, whether it will be liable to royalty. or not.
Exactly, madam. That is disputed.
And your Lordship, in the first case,
Hmm.
that was a private petroleum land was supplied somewhere else. This is not the case here. And in this case, I'm not asking, there is no contractual dispute. My learned friend is appearing for the royalty on the government of Assam, and he's saying about the contractual dispute. Where is the contractual dispute? There was no contract with the forest
There's
department.
no contract.
I'm not on that, madam. I was like at a dispute partner.
There's no
Oh, let's
contract.
I'm highly obliged.
Because this is something which I had seen earlier. Therefore, I recollected what the matter was about.
Right.
You'll find it in the middle of this judgment somewhere.
Yes,
The reason why the Supreme Court was moved, why the High Court was moved. You give me that judgment. I'll-
Recently, you asked me, see, the judgment has come before the public law body and.
well, I have a copy, but my
The scope has been
mark it
widened.
like a kid.
Just show it to me because very difficult to find in the ebook. Give it to me, I'll find it out.
Well,
In the middle of this, you will find somewhere.
well,
in
kindly
this case.
excuse my these drawings and
okay.
all these things. Not drawings, but I mark the paragraphs. Oh, Malwan, sorry, I have given another one. Read you what. Joshi Technology. This is clear, man. This is clear. That was drawn, man. Some calculations, some listing numbers.
Yes, para 17 and 32. I think this judgment, the discussion is earlier. Facts are in the middle and the Supreme Court's own verdict is later on. Sequence is very difficult to follow in this judgment. First is the nature of dispute, then
My lord.
arguments, thereafter, what you call the opinion of the court, then facts, then again the opinion of the Supreme Court. 17 and 32, now you get it?
Yes,
It wants an amendment to the agreement, that
Yes.
can't be done by a read court.
Unless until the entire judgment is nowadays.
Huh?
Unless the entire judgment is ready, very difficult.
At times, yes. I'll pass orders together.
Matter number 2.
Always, sir.
My lord, before my learned friend starts, in this case, my lord, it's my duty to point out. On the last occasion, my lord, the department went unrepresented, but for a simple reason. In fact, my lord, there was a prayer made for taking up the matter at 2 p.m. inadvertently, my lord, not informing me. And my lord, a mistake was also made by affixing in the list, my lord, saying that the matter is adjourned. So I was of the impression, my lord, that the matter was adjourned. My lord, after the matter was taken up, I was informed by somebody that the matter is taken up, but it is represented by nobody. By the time I came here, my lord, the court has already, my lord, had risen. So I'm sorry, my lord,
Okay.
that on the last occasion I could not represent, my lord, the department. But here is a case, my lord. In fact, there is another primary issue which, my lord, is required to be, my lord, first ascertained by your lordships, my lord. In fact, on the first day when the matter was moved, my lord, though not in specific terms, my lord, the honorable court directed me. But in fact, the verbally, my lord, the honorable court asked me to obtain the instruction, my lord, whether the ARCS, my lord, is competent to adjudicate the election dispute, my lord, in terms of Rule 27.
Okay,
Rule 27 says, my lord, it is the election authority. Now, in terms of the definition, my lord, it is the registrar or any other officer, my lord, who has been delegated the power. Now, under the Act, my lord, Section 3, my lord, a notification has to be issued to delegate the power, my lord. So these rules, my lord, having been framed, my lord, under the Act, the question is, my lord, whether any notification is issued, my lord. So this is a primary, my lord, issue, my lord, which will have a ramification if your lordship, my lord, decides, my lord, the writ petition without first ascertaining this aspect of the matter. Now, I had, my lord, sought for the instruction, my lord, but no instruction is forthcoming. Perhaps, my lord, the order is not very specific. So what I pray, my lord, lordship will, my lord, pass a specific order to this extent, my lord. Whether a notification has been issued by the government delegating the power, my lord, to any other officer other than the registrar, my lord, to resolve, my lord, election dispute, my lord. That is the primary issue, my lord, in this case. Otherwise, it would have a ramification, my lord.
no, you see, you've seen the last order, 31-5. You see this order.
My lord. An order without compliance with. Yes, my lord, I have seen, but basically here, my lord, his challenge is that, my lord, he was not heard. But
Yes.
still, my lord, the fundamental question, my lord, remains whether the ARCS, my lord, is competent to pass an order. Because under the rules, my lord, it is the election authority, rule has been defined. My lord, the election authority has been defined that it is the registrar,
Registrar.
my lord. And if your lordship comes to the Act, Section 3, my lord, Section 3(2), because this is the fundamental question. Otherwise, my lord, it would have some ramifications, my lord. In other cases, if an officer not competent, my lord, to pass his order, that would, my lord, create complications, my lord. My lord, Section 3(2) says, my lord, that the state government may appoint any
Just-
other
just-
person.
Just a moment.
My lord, my lord.
Where is the High Court order?
Page number 67.
67.
Yes. Relevant paragraph 74. madam. 13,
So
14.
here it says it's only the, what you call, election authority,
Yes, yes, correct.
correct?
Election authority.
So election authority, if according to the Act, you are saying that the registrar is the competent authority.
Competent authority.
Then let the registrar do the exercise.
Yes, correct, my lord. Correct. But there has to be some, my lord, observations from your lordships, my lord, that it is the registrar under the, my lord, rules, my lord, and in terms of the definition. That would, my
So
lord, in
this-
fact, I have no objection to that.
You are appearing the matter?
Yes, my lord.
Yes.
My lord, I am, my lord, instructed by the respondent number 7, 8, 10, 11, 15, 16, 17, and 18, my lord. And
Yes.
to this effect, my lord, I have also filed one caveat, my lord. This is number, my lord, 499, my lord.
Yes.
Caveat one, I have also registered caveat, my lord.
No, it's okay, but what do you say about the legal proposition? If the election authority is the registrar, this assistant registrar cooperative society's order would be without jurisdiction.
I am not copy applying.
Give a copy to him at least.
My lord, it's. As my learned friend, my lord, the attending council mentioned, my lord, since the 2F of the rule says, my lord, the registrar or any other authority officer, my lord, delegated.
No, once he has appeared, you give it to him. We'll take it up at 2 o'clock if required.
Yes.
Because it's on a legal position. If the ARC, sorry, the what you call the assistant registrar of cooperative society doesn't have the authority, parties will have to be delegated to the registrar. No point keeping this matter pending here.
But Friday may be taken up, my lord, in the first matter.
Friday.
Friday, the first.
Okay, give a copy to him.
My lord, I propose, can it be this way? Lordship, my lord, in specific terms, direct the government to, my lord, punish, my lord, if any delegation of power is there, then, my lord, your lordship can decide the correctness or otherwise of the order of the ARCs.
Okay.
Otherwise, my lord, the matter, it is without jurisdiction, my lord.
Okay, heard Mr. M.J. Kadir, learned counsel for the petitioner. Mr. S.K. Talukdar, learned standing also for the Corporation Department. And Mr. A.M. Bormia, learned counsel for respondent numbers.
7, 8, 10, 11, 15, 16, 17, and 18, my lord. No caveats, my lord.
Okay, next para. It is noted that this court by order dated 25/1/2023 passed in WPC 395 of 2023, had directed the election authority to decide the representation of the appeal filed by their respondents here.
Petitioners, petitioners. We had filed that.
Oh, okay, by the petitioners. Full stop. However, from the impugn order dated 13/4/2023, it appears that the adjudication was taken up by the Assistant Registrar of Cooperative Societies, Silchar. Next, accordingly, the court query to the learned study council for the Corporation Department is whether the government of Assam, by any notification or amendment to the rule, to the Assam Cooperative Societies Election Rules, 2019, has delegated the power of adjudication of appeal in the matter of elections to the Assistant Registrar of Cooperative Societies.
My lord. Or any other officer other than the registrar.
Or any other officer other than the registrar of cooperative societies, Assam. Full stop. The learned standing council for the Corporation Department shall send a downloaded copy of this order to the authorities to enable him to obtain instructions. List on, then instead of Friday, we are making it Monday,
Correct,
Yes.
that would be convenient for me, my lord.
12/6/2023.
Always.
My lord, My name will be reflected. in that.
Okay, your Vakalatnama is not there on record.
My lord, I have submitted my caveat.
When?
After filing of the-
Last week, my lord.
after the
caveat
last
number
order.
499/2023. 499/2023.
4/9. But that,
499, my lord. So caveat
Take-
number 499/2023,
of which date?
my lord. Date, my lord.
The registration tag. Caveat number
499/2020.
499, 2020,
23, my lord.
23.
It is filed, my lord, on 26, my lord, 5/2023, my lord.
Okay, file out 26/5/2023 with this record. And reflect the name of the relevant council for the caveats.
My lord. Obliged.
I'll take a break and come back. Yes.
Item 3. My lord, this matter may be taken up at 2 p.m. my lord. Today. Develop.
Okay, we'll send it back then.
Yes, lordship. If your lordship want the notification, that notification, I've got a copy of that.
Item 4.
Yes. The notification sending it here and the notification again 435 amendment in 2020 that I am giving. Very good.
But Mr. Y.S. Manan, the counsel for the petitioner.
And one more point that is also urged was with regard to the, your lordship, speedy trial, which is there in 435. So in that case, your lordship will also fix a time limit.
I'm not fixing it. Let it go to the
At least
magistrate.
a mention for a speedy trial.
You be permitted to make a. Because I don't know the pendency of that.
No,
particular-
I'm not saying any date, you,
Ah.
just a speedy trial. As per 435, that's.
You see. You know, in Bihar. Because of this Prohibition Act. What is happening is. That there's a negative, what you call, negative burden is given on the accused person with whom liquor is found to prove his innocence. Correct. Now, as a matter of fact, what has happened is that in the High Court, I am told that bail matters in lakhs are pending. So bail matter, which is filed before the Patna High Court, comes in the motion column after about a month or 45 days, not beyond that. If you file a bail application today, it reaches the court for motion after
After a month.
after a month. That is what I am told. And the honorable judges who are assigned the bail bench are find it very difficult. So when I said to you that I don't know the pendency of that particular court, I said it to a purpose because I'm aware what happens is that if a direction is given for a time bound,
No, no, I'm not asking for timeline, right? I'm saying that as per 445.
In few of the courts, NIAC cases have blocked the entire channel of the
Maybe.
magistrates.
Your lordship, maybe it's true. I'm not saying.
No,
That is why I'm not asking
Hey,
for.
no,
a
no, it's
timeline.
okay. You move the court.
Yes.
We'll comment that.
Lordship will just direct to transmit the. That's.
And there, what is happening is somebody will throw a half, what you call, some amount of liquor in somebody's house, call the police, and this entire family goes to the jail. That is what is,
Then there is the difficulty of this.
that is what is happening. Ms. M. Chetia Laran,
He is a formal part.
the government advocate appearing for respond number 2. Next, Pradhan. In view of the nature of Grievance Residence's present writ petition, issuance of notice on the respond number 1 is dispensed with. More so, because of the reason that although the petitioner herein took steps on several occasions before the before the learned trial court, the appearance of the respondent number 1 could not be secured. Next paragraph. By filing this writ petition, this writ petition was initially filed under Article 227 of the Constitution of India, but pursuant to order dated 31/5/2023, the writ petition is now taken up as one under Article 226 of the Constitution of India. Full stop. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking for a direction against the trial court to ensure speedy trial of the proceedings of Sessions Special Companies IES Companies case number 5 of 2018, pending before the Court of Learned Additional Sessions Judge number 1, Kamrup Metro, Guwahati. Next paragraph. The case of the petitioner, in brief, is that the respondent number 1 is holding on to a company quarter and as the service of the petitioner was terminated, a notice was issued to the respondent number 1 to vacate the company house and to hand over vacant position back to the petitioner. Full stop. As the respondent number 1 did not comply with the notice issued on 13/1/2016, the petitioner instituted a complaint case before the
Page 39.
Court of the Chief Judicial Magistrate, Dibrugarh, which was initially registered as case number
1C oblique
1, numerical 1, capital C, oblique 2016. Full stop. Complaint case under section 452.
No, initially was, that was filed on 6/30,
No, no.
but
Acha,
4/5/2016, it was amended to 450.
acha, which was initially under section 630
of the
within
earlier-
bracket small b of the Companies Act 1956, which was later on converted to a complaint under section 452 of the Companies Act 2013.
As per order 4/5/2016.
It's okay, we're not. Full stop. The complaint under section 452 of the Companies Act, 2013 is tribal before the special court constituted under section 435 of the Companies Act 2013. And as per notification dated 5/2/2018, published in the Gazette of India under SO 528 within bracket capital E, bracket closed, comma, the Court of Additional District and Session Judge number 1, Kamrup Metro, Guwahati, was designated as the special court to try offences under section 452 CRPC. Sorry, Companies Act 2013.
In between, there were 3 amendments, but this amendment came in 2020.
So, where is that amendment?
That amendment, you'll also have given. One
Oh, this second page, this one.
This is a big gazette, you'll also, from there I have printed out the last 2 pages.
No, no, the number I will require. The notification number I will require.
That in fact, I think I have given your lordship in the, that day I have given 2 sheets of paper. In the one that.
Yes,
That 2 sheets of paper, your lordship will find substituted by Companies Amendment Act 2020 with effect from 22.
just pass that
I
paper.
have. There's my copy.
Next paragraph, the Learned Counsel for the petitioner has submitted that the
I have marked.
Companies Act 2013 has been amended.
The date has been, I tick mark the dates.
There's a section 430. Which provision is amended? 435 is amended.
435.
Achha, section 435 of the Companies Act 2013 has been amended.
That your lordship will kindly see.
By
They
way of
have given.
by
their
way of
specific-
substitution. As per the companies within bracket amendment, bracket close Act 2020 with effect from 22/1/2021 under SO 325 within bracket capital E dated 22/1/2021. And the effect of such amendment
That your
is-
lordship will take up this, the gazette notification specifically given. Just now I
the
have,
effect of
passed.
such amendment is that the offences under section 452 of the Companies Act would now be triable before the jurisdictional magistrates. Full stop. The provisions of section 60 of the amending act is quoted below. First it will be 60, then it will be amendment of section 435, then the text will come. Next paragraph. in view of the amendment made to the provisions of section 435 of the Companies Act 2013, by which the jurisdiction for trial of the cases under section 435 of the Companies Act, 452 of the Companies Act 2013 is vested on the jurisdictional magistrates. The court is of the considered opinion that this should be a fit and appropriate case for directing transfer of the proceedings of what is the number now
Which number you lost?
of Sessions Special Companies Case number 5 of 2018
Yes.
from the Court of Learned Additional Sessions Judge number 1, Kamrup Metro, Guwahati, to the Court of Learned Chief Judicial Magistrate. Which place? Dibrugarh. Dibrugarh. To adjudicate the matter. It would be the said learned court will have the liberty of transferring the matter for adjudication before the appropriate court, if so desired. Next paragraph. The Court of Learned Additional Sessions Judge number 1, Kamrup Metro, Guwahati, shall transmit the records of the said Sessions Special Companies Case number 5 of 2018 to the Court of Learned Chief Judicial Magistrate, Dibrugarh. Next paragraph, the petitioner shall appear before the transferee court on 23/6/2023 and await further instructions from the said learned court by producing a certified copy of this order. Next paragraph, the petitioner has liberty to move the jurisdictional court for expeditious trial. This petition stands disposed of.
I have to appear on 23rd here.
Yes, 23rd you'll have to appear.
Here.
No, not here.
In Dibrugarh.
Dibrugarh.
In Dibrugarh on 23rd. Here, actually, your lordship may only observe one thing. A copy of this order may be served because otherwise it will be difficult. Either from the registry or I'll
Oh,
serve.
okay, you will produce, and the
One
petitioner
line.
shall also produce a certified copy of this order before the Court of Learned Additional Session Judge number 1, Kamrup Metro, Guwahati, to bring the order to the notice of the said offence. Okay,
Otherwise, if it goes
I
on
know,
next time, that is why. I'm
it will,
trying-
otherwise it will
Because
take
again,
time.
23rd, I have to appear.
Okay. Yes, item 5.
That's all.
Yes, Mr. Islam.
May I please your lordship?
Ah.
My lord, this situation is filed basically against the inaction of the, my lord, police authorities.
I know last time we put a question to you.
Yes, your lordship.
The High Court is not converting itself to an executing court.
Yes, your lordship.
The jurisdictional magistrate would be having competence to enforce its order. Otherwise, you can come to this court under contempt jurisdiction.
My lord, application was made to that effect for non-compliance. I'm going to satisfy your lordship. Kindly see, my lord, the annexer 3 page, my lord, 28. The, my lord, direction part of this, my lord, learned jurisdictional court, my lord. Page 28. Operating parties, my lord, page 29. May I read, my lord?
Yes.
The IO in his report further stated that the fertilizer are required for further investigation. The Honorable Supreme Court in Sundarbhai Ambala Desai versus State of Gujarat reported in 2002 10 SCC test 83 held that
says article are not to be kept for a long time at the police station at any case for not more than 15 days to 1 month. Then considering the report of the IO as well as the direction of the Honorable Supreme Court as stated above, and that the says NIM quoted area is lying idle in the police station for more than 3 months. This court deemed it fit to exercise its power under section 457 of CRPC and allow the Zimma petition. IO is directed to hand over of the says NIM quoted fertilizer, urea fertilizer to the petitioner on his furnishing a Zimma bond of rupees 2 lakhs, and upon verifying the identity of the petitioner, Zimma petition is the Zimma petition is economically disposed of. Thereafter, my lord, would come to page 30, my lord. The petitioner filed Zimma, my lord, with an my lord application. This is the application, and the my lord bond is page 31. Bond of rupees 2 lakhs, my lord.
Yes.
Then your lordship would come to page, my lord, 6.
Page?
Page, sorry, my lord, page 33, my lord. Annex of 6.
Yes.
My lord, due to non-release of this, my lord, items, my lord, after submission of bond, my lord, the petitioner filed another application. My lord, would come to page, my lord, 34, operating part. Second paragraph.
Mr. Islam, I'll not be able to follow you. You see, please come to the sequence which I am referring to. You got an order on 19/4/23 for Zimma,
My lord,
correct?
my lord,
Now, as against order of 19/4,
my lord,
you prepared a bond
bond, my lord.
on 2/5/2023,
My lord,
correct?
correct, my lord.
Now, this to the officer in charge, page 30, you are showing that you have given, but we don't have any endorsement that you have given it there. Now, 32A,
My
you
lord,
send this to the officer in charge by registered post on 4/5,
my lord,
correct?
my lord,
And on 4/5, you move the, what you call, magistrate.
my lord.
Now, if you, if you are sending the bond by registered post,
No, my lord, he personally, my lord, appeared before the IO. That I am going to show, my lord, in last order, my lord, when IO appeared, he himself, my lord, stated that, my lord. On 4/5, my lord, page, my lord, 33. This application, on the basis of this application, page 34, my lord.
I'll not be able to follow you. You see,
Then, my lord, kindly come
you,
to
you
page
see, your bond is of which date? 2/5,
2/5, my lord,
2/5.
my lord,
You come to page 33 in your petition, you are writing,
my lord,
petitioner said, as for order of this court dated, he approached the OC.
my lord.
When did you approach?
Immediately, my lord, after this, my lord, bond, my lord. On the same day, my lord, on my lord, 2/5, my lord.
Where is that?
My lord, kindly see page, my lord, page, my lord, 39.
Page 39,
Page
yes.
39, man. Page 39, when my lord IO was personally called, he appeared before the my lord learned jurisdictional court. This order, my lord, may I read?
Yes.
The petitioner is present, represented. OC Panchgram is present and has submitted reply to show cause notice. The OC concerned has stated both verbally as well as in his report that the Zimma of the vehicle bearing registration number so and so has already been given to the petitioner as per order of this court. He also stated that regarding the Zimma of says quoted urea fertilizer, none has appeared before him claiming the ownership over it, and therefore the same cannot be given Zimma of anyone till date. He also stated that he was availing leave and was not present at the time when the petitioner visited the office police station, although he had visited, he has advised his subordinate staff to deal with the matter, and his subordinate staff, due to inadvertent mistake, could not follow the order of this court, which was not at all intentionally. So, my lord, from this, my lord, revealed that my lord petitioner appeared before the my lord IO, my lord. And due to his inadvertent mistake, my lord, this says NIM quoted urea was not released, my lord. Then, my lord, hence the show cause reply provided by the OC, Panchgram PS is hereby accepted. The petitioner is directed to appear personally before the OC, which is a valid identity proof and proof of ownership over the seized articles. And the OC is directed to follow up the procedure and to give custody of the seized coated urea fertilizer to the petitioner upon his satisfaction. Then, my lord, on very next day, my lord, this is order, my lord, 18/5. Then on 19/5, my lord, he appeared before the, my lord, IO, my lord. And he was made to sit, my lord, whole entire day in the, my lord, police station. Thereafter, he approached the, my lord, of OC, my lord, the superintendent of police. Then he, my lord, filed the representation. So, my lord, basically, my lord, they are not, they are refusing to, my lord, release this product. My lord.
Okay. I'm closing this petition, permitting you to move this court by contempt proceeding.
Contempt petition before this honorable High Court.
Because I've told you earlier also, I made my mind clear. You get an order from the magistrate's court.
My lord.
High Court is not going to execute it under 226. That is what I'm not doing.
My lord.
You will be permitted to move this court under under 11 and 12 of the Contempt of Courts Act.
My lord.
If the order is not being complied with.
But I am filed basically in earlier in a similar case, your lordship. I have given this document earlier. And in this case, your lordship, notice was issued, and during the pendency of this case, my lord, the grievance of the petitioner has been, my lord, settled. So, my lord, basically, your lordship kindly issue a notice, my lord, at this stage. If required, your lordship give us liberty to file, my lord, contempt petition.
No, two proceedings I will not permit.
My
You
lord,
file
at
it
least-
within
at
2
least-
days, you file it.
My lord, notice may be issued, my lord. Absolutely.
We will permit you to take back your Wakalatama. You file your fresh application. If you want, we will permit you to take back your Wakalatama from the record and file it again. For this, I am Islam Learned Counsel for the petitioner. And Mr. M. Chediar and the advocate appearing for the
All the respondents.
respondents. Next paragraph. The petitioner had opposed the Court of Learned Judicial Magistrate First Class, Hailakandi, with an application for application under section what was it, 457 or 471, which 451, which
457, my lord.
filing an application under section 457 CRPC for obtaining custody of the seized neem coated urea within bracket fertilizer in respect of which Panchgram PS case number 6 of 2023 under section 120 capital B 420 379 411 IPC was registered, which is corresponding to GR case number 67/01/23. The learned Chief Judicial Magistrate Hailakandi, by an order dated 19/4/2023, allowed the custody petition and directed the IO to hand over the seized neem coated urea within bracket fertilizer to the petitioner on his furnishing a Zimma bond of rupees 2 lakh and upon verifying the identity of the petitioner. Next, the learned counsel for the petitioner has submitted that pursuant to the said order, the petitioner prepared a bond, executed a bond on 2/5/2023 and went to the officer in charge of Panchgram PS post of however the seized fertilizer was not released to the petitioner. Full stop. The petitioner again approached the court of learned Judicial Magistrate First Class Hailakandi with petition number 266 of 23. The project that the order dated 19/4/2023 allowing custody of the seized neem coated urea was not complied with. Accordingly, the said learned court by order dated 4/5/2023 directed the officer in charge to be personally present on the date fixed for appearance. The officer in charge of Panchgram police station was absent, and a reminder for appearance on 18/5/2023 was issued. However, on an off date, i.e. on 4/5/2023, the officer in charge of Panchgram police station appeared before the learned Judicial Magistrate First Class Hailakandi and explained the explained his position. And accordingly, the said learned court directed the officer in charge of Panchgram police station to personally appear and show cause. No, it is wrong. No, it's wrong. We just try it out. No, wrong. That last caravan number there. It will be till the personal appearance on 11/5/2023. Till there. On the date of appearance, 18/5/2023, the officer in charge of Panchgram police station appeared before the Court of Learned Judicial Magistrate First Class Hailakandi and admitted that the petitioner had visited the police station with to take zimma of the seized neem coated urea within bracket fertilizer, and as he was availing leave, due to inadvertent mistake, the subordinate staff could not follow the order, which was not intentional. And accordingly, the said learned court accepted the explanation of the officer in charge of Panchgram police station and directed the petitioner to appear before the officer in charge of Panchgram police station with his valid identity proof and proof of ownership of the seized articles. Full stop. Next, the learned counsel for the petitioner further submits that the petitioner again appeared before the officer in charge of Panchgram police station on 19/5/2023 at 10 a.m. But the seized fertilizer was not handed over to him without fulfilling his immoral demand. And it is alleged that as the petitioner was incapable of fulfilling his demand, the officer in charge of Panchgram police station had not handed over the seized consignment to the petitioner. Full stop. Accordingly, a complaint was made before the Superintendent of Police, Hailakandi, on 24/5/2023. Full stop. From the above projection, it privacy appears that there is a willful and deliberate non-compliance of the order dated 19/4/2023, not only by the officer in charge of Panchgram Police and the IO of Panchgram PS case number. What is the case number?
Case number Panchgram PSK 6 of 2026.
6 of 2023, covered also by the officer in charge of Panchgram Police Station, as well as the Superintendent of Police Hailakandi, to whom a complaint was formally made on 24/5/2023. Full stop. The learned counsel of for the petitioner has been privacy able to satisfy the court that because he was unable to fulfill the moral demand made by the officer in charge of Panchgram Police Station, consignment was not handed over to the petitioner. Full stop. Next paragraph. This court is of the considered opinion that in exercise of power under Article 226 of the Constitution of India, the court ought not to execute orders passed by the learned trial court, as there are alternative mechanisms available, which is by way of filing an application to enforce the order dated 19/4/2023, or to approach this court under contempt jurisdiction. Full stop. Next paragraph. In view of above, although the court is disinclined to entertain this writ petition, but the same is only for technical reasons as assigned above. Full stop. Accordingly, the court grants a liberty to the petitioner to approach this court by way of under the contempt jurisdiction. Full stop. The petitioner shall produce a certified copy of this order before the Superintendent of Police Hailakandi, and if within 7 days without any lawful cause, the order of the Judicial Magistrate First Class Hailakandi dated 19/4/2020 is not complied with, the petitioner would be at liberty to approach this court under contempt jurisdiction. Full stop. Approach this also by an email. To the Superintendent of Police, just where I've said he's approached the Superintendent of Police, make it by email. Next paragraph. For ends of justice, the Honorable Government Advocate shall also communicate a downloaded copy of this order to the Superintendent of Police Hailakandi to bring the order to the notice of the said authority. I have previously recorded my satisfaction of a contempt. You give an email, it doesn't give you, then within 7 days you come back. Contempt jurisdiction.
But in the meantime, the police authority.
If they
released
give
the-
good enough, I have given that liberty.
My lord,
I have given that liberty. If you get it,
sir,
well and good.
One observation may be given on that matter. If they release in
I've
the
already
meantime,
made that observation. I want you to come in contempt jurisdiction.
highly obliged, your lordship.
Yes, item 7. Yes.
Industrial policy was announced. And we should also find page 39.
I think two fat matters in a day is good enough. Why third?
Here I'm only paying for a notice with it.
Okay. Only notice. That I'll be glad.
Because we don't hear the, actually policy, my lord.
I know industrial policy. You want,
Page 46,
you are saying that the impugn action is contrary to clause 4.3.
my lord, because
That
it
is
says
okay.
that all eligible units shall be entitled to subsidy, irrespective of the getting the
Okay,
benefits.
I'm
under
issuing a
the-
notice.
Now, under food processing, some amount was given to me assistance. Now they are deducting that amount from the amount which is payable under the scheme.
Okay, I'll also issue a notice on the prayer for interim relief.
Lordship,
I'm also issuing a notice on the prayer for interim relief.
lords.
Her doctor. Ashok Saraf, Planet Senior Counsel, assisted by Mr. Anand Datta, counsel for the petitioner, as well as Mr. K. Govil and its CGC appearing for respondent number
1 and 3 lordship.
1 and 3. And Mr. A. Kalita Lanet, standing counsel for Industries Department, appearing for respondent numbers 2,
2, 4, 5 and 6.
2, 4, 5, and 6. And who will be for 7? This Northeast Industrial Development Finance Corporation.
Lordship,
Who will be appearing for 7? Northeast Industrial.
there was one G Das, Gitartha Das. G Das is usually appears for net fee.
No, he's not net fee. This is
Oh, sorry,
Northeast
I'm sorry, I'm
Industrial,
extremely sorry, Lordship. This is the.
Northeast
I'm not sure
Industrial
about this.
Development
This
Finance
financial
Corporation.
company, the finance company, I'm not sure.
Will issue notice to him? Oh, okay.
Regular notice.
We issue notice of motion including notice in the period for interim relief, returnable on. When, Mr. Kalita?
4 weeks, Lordship. Okay, basically, this is Lordship's central government scheme and an empowered committee is the main body, Lordship. Empowered committee of the central.
19/7/2023.
Lordship.
Requisite extra copies of the petition be served on the run at CGC and Department of Council in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on respondent number 7 by registered post with AD. Can it be served by Dasi also? It will be faster, otherwise
My lord, instead of 1921 lordship.
21, okay, 21. In addition, notice be served on the respondent number 7 by way of Dasti by routing the process through the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. This 7 is only a pro forma party.
It's a case where this one of 7 impact is a profound.
Okay.
Mainly the central government.
Next, the pendency of the petition shall not be a bar for the appropriate authority in the central government and in the state government to examine the claim of the petitioner and to take an appropriate decision. List on 21/7/2023.
8.
The matter parties to non-payment of the contractual bill, your lordship. The petitioner executed,
This contractor's bill.
I have completed the work in the year 2019 also, and monitoring committee has already submitted report to the authority.
It's okay. I'm not saying anything else here. Mr. Airborne, counsel to the petitioner, non-payment of contractual bill. Notice extra copies. Mr. Nayak will be appearing for
Lordship, I am appearing for respondent number.
Mr. T. Nayak, standing question for Finance
Lordship.
Department, appearing for respondent number 2.
Yes.
And you're for
I am 1, 4, and 7
1, 4, and 7, Miss
on P. Bora on behalf of
P.
V. Raspa as extending council corporation department
P. Bora,
on behalf of V. Raspa.
G. Rajkwa,
V.
B. Rajkwa. Standing counsel for
Corporation department
cooperative department, appearing for respondent number 1,
1, 4, and 7.
4, and 7.
Yes.
Will be appearing for Housefed.
Hospital, they have their sending council, Lordship.
Who is he?
And Gogoi, Dularam Gogoi, T. Gogoi, Lordship. T. Gogoi.
P. Gogoi.
Lordship, may record his name, Lordship. I'll inform you,
T. Gogoi for respondent number 6. And this 8, who is the district level monitoring and evaluation committee? Who is this?
It is represented by the Lordship, the member secretary, Lordship, cooperative society. They have the district and or name.
So you'll appear for them also? 8 also?
District administration or what? District or what?
For 8 also, he should be appearing. What is given? Pendency of the repression shall not be a bar for the competent respondent authorities to examine the claim of the petitioner and release payment if found due. 9. Yes.
This matter is a 9, 10, 11, 12. It's the same matter. The petitioner is before Lordship. Is a small businessman having running with restaurant, and to applicant they apply for the IMFL on license as per provision of the Excise Act. And their application were duly accepted after receiving the 1 lakh of rupees of treasury.
What is at this stage?
And therefore, that is process is initiated.
I'm only issuing a notice at this stage.
Process is initiated. Lordship, kindly come to Annexure D, page 19.
It's okay, I can't do anything else. I can issue a notice at this stage.
Yes, yes. And
Mr. P.P. Barwal and counsel for the petitioner. And Mr. N. Goswami Leonard, government advocate appealing for.
I'm bringing the standing council's exercise for 1, 2, and 4 lots.
Okay, standing counsel for excise department appearing for respondent numbers 1,
2 and 4.
2, and 4. And Mr. M. Chediar and government advocate appearing for respondent number 3. Issue notice of motion returned within 4 weeks. Requisite extra copies of the repetition will be served on the State and Department Council in course of the day. Next, the pendency of the repetition shall not be a bar for the competent respondent authorities to examine the application of the petition and pass appropriate orders. All 3 are, next 3 are same.
Lots.
here,
Okay,
All
same
are same.
orders. Item 9,
10,
11,
11,
12.
Lots.
Okay. Extra copies in course of the day.
Lots.
Resume at 2.
Lots.
Lordship, may I have one prayer, Lordship?
Yes.
Item number 53 to 57, Lordship. These are content matters, Lordship. We have already filed our affidavit, Lordship. Lordship, today I have some problem, Lordship. I have, the other side is also present. Lordship, I take up this matter after 10 days, Lord.
50,
53 to 57, Lordship.
53 to 57.
Yes.
Okay, both sides are represented. On the prayer made by Mr. P. Nayak, counsel for respondent number 1. List on.
And after 10
After
days.
10 days,
After 10 days. Okay.
Lordship.
We are occupying a land of the, my lords, the Oil India Limited, but actually, my lords, we are in possession of the land.
No, no, that means you don't know the concept of ROW.
No, I
Right
don't
of,
know,
right of way is, doesn't, the land belongs to X, Y, Z. It's only the right of way which is given to the Oil India Limited.
Yes.
They are not the owners of the land.
The right of way, maybe, according to them, there is a pipeline, my lord, according to them.
No, whatever be, but if there is an ROW, you will not be entitled to any relief.
No, my lord, here, our case is that, my lord, since 2000, that means for 23 years, my lord, they did nothing, my lord. Now, my lord, we have been,
Where is the notice of 8/5/23, which page?
page 35, my lord. Page 35.
Okay, this stage will issue a notice. Who's appearing for Oil India?
But actually, my lord, they informed me that after notice is issued, they will.
Achha, okay. But Mr.
I-
I Chaudhary and counsel for the petitioner. Mr. M. Chetial and government advocate appearing for respondent number. Yes. Petitioners, yes. For number, for 2, 4, 2 and 4. And Ms. G. Hazarika and standing counsel for Revenue Department appearing for respondent number 1 and 3. Agreed by the notice dated 8/5/2023 regarding encroachment of inverted commas right of way of Oil India Limited. The present writ petition has been filed under Article 226 of the Constitution of India. Issued notice of motion including notice on the prayer for interim relief returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned state and departmental council in course of the day. So the petition shall take steps for within 2 days for service of notice on the respondent numbers 5, 6 and 7 by registered post with AD. And in addition, the notice will be served on respondent numbers 6 and 7 by way of Dasti by routing the process through the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. List on list or give a date after 4 weeks.
My lord, one framework they can carry not to take coercive action till then.
No, you on ROW, they don't take coercive steps. All India doesn't demolish any structure. They will tell the what you call deputy commissioner to get it enforcement free. That is the process.
21/7.
Nothing, make it early. Instead of that long. And make it 23/6. Give me a short date. 23/6.
13.
Yes, Mr. Roy, your matter. Yes.
The petitioner is the owner of a plot of land within Kolkata Taylor. And he has obtained building permission from the GMD and GMC for construction of a ground plus 2 building. but due to financial constraint, he could not construct. Then respondent number 7 and 8, they are the builder's lordship. So builder entered into an agreement for the development of the landlordship. But what the builder did, instead of in the development agreement, it is mentioned that the builder will obtain. fresh
Mr. Roy,
landlord.
you see, your synopsis is of about 7-8 pages. I've not been able to follow it. Just if the synopsis is 7 or 8
It is
pages,
A bit long.
it is, I find it very difficult to follow it. If I try to read 9 pages of synopsis, not even 8 pages, I think it's more.
Lordship, I'll make it
But
shorter. This
In
will
a
take-
motion matter, you don't expect me to read this 7 or 8, 9 pages of this and understand what you're trying to say.
Yes, yes.
I'll just issue a notice, nothing more.
Only I pray only for notice, nothing.
I had Mr. SP Doyle and counsel for the petitioner. And Mr. M. Setial and government advocate appealing for respondent numbers. You are for whom? Oh, in fact, I now am, and I now understand why I did not read it. Okay. You see, here, your case is that the building of respondent number 7 should be demolished.
Lordship,
Correct.
because,
This would amount to issuance of a writ against private respondent.
no, because Lordship, the demolition work is to be taken by GMC.
No, if GMC doesn't take any action, at the end of the GMC Act, there is an appeal provided for
Lordship,
before the state.
Lordship, the permission was only for ground plus 2. He has constructed.
No, but you see, you have to satisfy me. That's why I think I did not read it. You see, the demolition order is against respondent number 7 and 8.
No,
Correct.
no, demolition order is against the petitioner. GMC issued the notice under section 337 in the name of the petitioner, though I have not constructed the building.
I don't know. Look at your prayer at page 68. Why building constructed by respondent number 7 and 8 over the land is should not be demolished.
Yes, because.
So that means it's a relief claimed against the private respondents.
Lordship,
Why would a writ be maintainable?
I have annexed notice, Lordship. Demolition notice was issued in my name because what the builder did, Lordship, he constructed on my NOC, Lordship. He did not obtain the fresh NOC from the GMC GMDA as per the development agreement. So only I pray for notice.
No, then if the development agreement has not been adhered to, it's a civil dispute. Why writ should be entertained?
Lordship, the builder has constructed violating the even my NOC, Lordship. Lordship, please to consider that my NOC only for ground plus 2. He has constructed ground plus 3 builder, Lordship. So that is complete violation of the building bylaw zoning regulation. And that's.
I don't know if that is your statement. Come to page 179. Height of 3 meters at third floor. You have yourself produced a NOC. This notice you have produced.
This is Lordship, my NOC, which I obtained, Lordship, from the GMD and GMC. But this is not the NOC in the name of the builder. I am Neba Prasad Yadav, that is the petitioner.
Where is your agreement?
Agreement, Lordship. Lordship, page 90.
90.
90.
Yes.
Correct, sir.
Where is the clause that he'll have to take a fresh?
Yes,
uh,
yes, Lord.
Where is that? Because Mr. Roy, somewhere I read it in this agreement I vaguely remember, I don't know, because I didn't read to ask you questions. In this agreement, there is an arbitration clause.
Yes,
So why it should be entertained?
arbitration lordship, that's a different matter entirely, when there will be dispute between the builder and the petitioner lordship. Here the dispute is with the mainly GMC and GMDL lordship.
Sir, Mr. Roy, I'll be dismissing it. We will give you liberty to move an arbitration. Where is the arbitration clause in that agreement?
Or arbitration already completed. lordship.
14.1 and 2. So
Lordship.
if let the arbitrator decide.
No, arbitrator only decide, abate has been delivered, I have annexed the copy. of
Where
the-
is that?
Yes.
You see, that is the difficulty when you write a synopsis of 8 to 10 pages. I can't follow anything.
About copy I have annexed.
Where is that? Because if there is an award can be executed like a decree under the Arbitration Act.
Lordship, that was a dispute between the landowner and the builder lordship. And the arbitrator was appointed
Where is
and
that
award
award?
has been delivered.
Where is that award?
Yes. 233 lordship. 233. And actual 46. If you ever know. 233. Page 230. What has been passed in my favor, Lord, and execution is.
Where is the completion certificate? When was the construction completed?
No completion certificate has been issued by the GMC because that was the duty of the builder to obtain the possession certificate.
Which page was that? What do you call? This agreement, I forgot. Which page was the agreement?
Yes, Lordship, agreement. Page 90, Lordship. That's it.
Yes, I'm sorry. When we were in this agreement, where is that clause that he'll have to take his own NOC?
Yes. Lordship, may we please to come to page 95.
Yes.
95. So is the start from clause 5.1.
Yes.
Developer shall be solely exclusively responsible for construction of the said building and the building shall be named. Then your. Lordship, clause 5.3, developer shall be authorized in the name of its own insofar as is necessary to apply and for obtain allocations, apply for obtain temporary and permanent connection, water, electricity, this and that. And
The developer shall also construct, erect and complete at his own cost, the entire building. Authorized in his name, so far as apply for quota entitlements and other allocations.
Yes, and Lordship,
This is not building permission.
no, here also Lordship, point 5.6, the developer shall after the completion of the construction of the said building shall apply for and obtain completion certificate in respect of the said building from GSC, GMT or any other authorities, whichever is authorized. So only the unless the permission NOC is obtained, Lordship, it will not be responsible of the builder to obtain the possession certificate or occupancy certificate.
Mr. Roy, I will be dismissing this declaration on the ground. Number one, this agreement is of 2012. As per the award, the flats were handed over to the claimant by letter dated 11/12/2014. So 2014, you got the possession, and now you are raising this dispute in 2023, when we have already approached the arbitrator for the same.
Arbitration is entirely on the different subject, Lordship.
No, if you don't choose to include one part of the claim in the arbitration, the court will not entertain this application.
Lordship, may I please to come to page 107.
107.
7.
Private dispute, you have to go to civil court, not to the high court and then get a shortcut. Yes, 107.
Yes, clause number 2. In the middle, to do the needful and obtain building permission in the name of its company or its nominee or any attorney holder or any other, as may be convenient from the GMDA.
Mr. Roy, this is not acceptable from you at least. From others, I could have accepted this. You see, terms of the agreement, you are unable to show this clause that he'll have to get a permission from his own name. You are now showing me a power attorney by which you have inserted a clause. You see, a power attorney will not override the substantive agreement.
No, this is the agreement.
No, this is a power attorney. That much I have read. It's a part of power of attorney.
I have not done, sorry, I have not done my work properly. This
No,
will be
no.
taken on Friday.
We'll dismiss it, Mr. Roy. Why should we hear it,
Your
take pain
Lordship,
to read it and
Your
then
Lordship,
take
may
an
I please to
adjournment?
dismiss on Friday, because due to shortage of time, I could not do my homework properly. I must agree.
I have 20-25 motions. I have read a bit of it.
That is the capacity of your Lordship.
No, it's not a question of capacity. It's a duty I have been cast. I have taken it by as a matter of what you call duty to do it. Otherwise, I wouldn't be able to understand. One matter is a tax matter, other is a service tax matter, third is a construction agreement. If I don't read, I wouldn't understand what you are trying to say. Because the reason for not reading this synopsis, now I remembered why I did not read this.
Agreement also, Lordship, there is a clause that the builder is obtained.
Oh, okay. On the prayer made by Mr. Aspire, counsel for the petitioner, this on for Friday. Mr. M. Shedial, and government advocate, and Ms. S. I always forget your name, sorry.
S.
S. Shedial, counsel for respondent number
123.
120 are present. Okay. Yes.
14.
Friday.
Public.
Unpaid.
Yeah.
Unpaid bill.
No, my lord.
Then
There is, in this case, what is NIT was issued for construction of a road under the Mukhyamantri Pakki Nirman Asoni, my lord. So we submitted our bid was not accepted, my lord. By 6/4/23 letter of acceptance was given, performance deposit was asked to be deposited. We deposited on 11/4, my lord. Now they have to execute the contract with us. And the
Okay.
time of completion is 9
Issue
months.
notice.
Yes, sir. My lord. Time of completion is only 9 months.
okay. And Mr. B.J. Ghosh, and counsel for the petitioner, and Mr. B. Gogol, and a standing person for the
All the respondents.
respondents. Next para. Agreed by the non-issuance of contract agreement
Yes.
and issuance of formal work order.
On
the petitioner has
21 Lordship.
filed this writ petition under Article 226 of the Constitution of India. Issue notice of motion written over then so and so. Requisite extra copies of the writ petition be served on the United States, then the Department of Council in course of the day. Next para. The pendency of the writ petition shall not be a bar for the respondent authorities to issue a formal work order and enter into a
signing
contract
of
agreement with the petitioner in respect of the work referred to the writ petition. Give copies to him. Yes.
15,
Yes,
My lord, here my lord petitioner was awarded a contact matter. In fact, my lord, the letter of acceptance was issued, my lord. Subsequently, he had completed more than 10% of work, my lord. Therefore, my lord, their package was re-tendered, my lord.
thereafter,
Their package, my lord, the work was re-tendered, my lord.
work
Now,
was
my lord,
re-tendered.
Now, my lord,
This is the same matter. 2 days back, we took up same matter,
The package is different.
package is different.
Here he has come up for some running bill. that is-
Okay, I'll issue a notice here.
my lord.
Mr. S. Hawk, counsel for the petitioner. Mr. B. Govil, and standing counsel for the respondent numbers 1 and 3.
1, 2, and 3.
1, 2, and 3. And Mr. A. K. Nath, counsel for respondent number 5, 4 and 5. Sorry, CGC, 4 and 5. Agreed by non-payment of contractual bills and non-refund of bid security, the present writ petition has been filed under Article 226 of the Constitution of India. Notice extra copies. Pendency of the writ petition shall not be a bar.
Right.
Okay.
Apply.
16,
Yes,
Petitioners are the beneficiaries of the PMI or AYC houses, my lord. They are below poverty and they are entitled to get the houses, but
you can issue notice.
Right.
Had Mr. B. Islam, learned counsel for the petitioner. Miss
N. Bora.
N. Bora, learned standing counsel for the PNRD. The petitioners as appearing for respondent numbers
3, 4, 5, 6, 9, 10, and 13.
and Mr. N. Goswami, learned government advocate appearing for respondent number
2, 7, and 8.
2, 7, and 8. CGC will be appearing. Huh? Mr. K. Govil and CGC appearing for respondent number 1. Giving entitlement to houses under PMAY-G under 45 number Tupamari, TUPA-MARI, Gaon Panchayat in the district of Kamrup. Petitioners have filed this writ petition under Article 226 of the Constitution of India. Issue notice of motion, returnable in 4 weeks. Requisite extra copies of the writ petition is served on the State and Department Council in course of the day. Petition shall take steps within 2 days for service of notice on the respondent numbers 11 to 15. You are appearing for 9 and 10. You are appearing for 9 and 10 also.
9 and 10.
So private respondent 11 to 15 by registered post with AD. Learned counsel for the petitioner is permitted to collect the postal receipt number and submit postal tract report prior to the next date of listing. Next part, the pendency of the writ petition shall not be a bar for the concerned respondent authorities to examine the claim of the petitioner for their entitlement to PMAY-G houses as per beneficiary list of year 2020-2021 in respect of 45 number Tupamari Gaon Panchayat. Okay. 18. That was 17. Right, okay. Acha. Yes,
Madam. The petitioner is the legal year of legal year, my lord. He got the land by inheritance, but that was divided into three brothers, my lord, 8 biga, 12 plus R. But their portion was sold out. Now they are intending to possess the land of the petitioner. In regard to the possession, my lord, the petitioner filed one representation before the.
your writ petition will be dismissed. In a writ petition, you want an eviction.
Not, madam.
Then?
One for demarcation.
Look at your prayer, Mr. Islam.
Yes. For survey demarcation, madam.
Why writ should not be issued to vacate the land from possession of the petitioner? We'll dismiss your writ petition.
Actually, my lord, it would be, my lord.
No, no, we don't know that. You file a fresh writ petition. We will not permit this.
Then, my lord, I can, I may be allowed to withdraw and.
Ah,
I'll
okay.
refresh, my lord.
Upon instructions, Mr. B. Islam Land Council for the petitioner seeks to withdraw this writ petition and approach again by deleting the prayer for eviction of the respondents, private respondents. First of Mr. N. Goswami, Learned Government Advocate,
For 2 and 3 lots.
for respondent numbers 2 and 3, and Ms. P.R. Mohanty, and then counsel for the Government Advocate referring for respondent number 1 are present. The prayer is allowed. Matter stands dismissed on withdrawal with liberty to approach again without the prayer for eviction of the private respondents.
Legal.
Yes, Mr. Bhuya.
My lord. May I please your lordship?
Yes.
My lord, the advance of the petitioner, my lord, is that a land measuring, my lord, 18 lessons had been duly settled in favor of the parents of the petitioners.
Against the order of settlement, there is an appellate provision before the government.
No, my lord, the settlement, they have cancelled, my lord. The settlement which was given long back, they have
No,
recently
but
come
against the
up.
order of settlement, settlement orders are normally passed by the revenue authorities,
My lord,
secretary
my
level.
lord.
So against that, there is a provision for appeal.
That is correct, my lord, but very good case is a little bit of difference. If my lord maybe allow me to, my lord, to.
Yes, yes, please go ahead.
Narrate the sequence of events, my lord. My lord, maybe
Yes.
please to peruse page 25, annexure 1, my lord. This is a letter, my lord, issued by the government in the revenue
So
department.
first of all, where is the land? Where is the
My lord.
description of land?
My lord, the description of the land is, my lord, 18 lessons covered by, my lord, Dag number at paragraph 2 at page 6. My lord, I have stated, my lord. 18 lessons covered by Dag number 132 of village Sorumotoria under Moja, Beltola Moja by an order dated so and so government of Assam, my lord, has issued this settlement order, my lord, at page 25, my lord.
Yes.
Now, my lord,
Okay.
this is a letter issued long back in the year 2006.
Yes.
Addressed to the deputy commissioner by the government, my lord. May I read over the content, my lord? With reference to your letter, I am reading at page 25.
Just a moment.
My lord, my lord.
Page number?
Page 25, annexure 1, my lord. This is a, my lord, letter addressed by the
Yes,
government.
this is
in
an
the-
allotment letter.
My lord.
Yes.
Settlement of land with respect of so and so and so and so.
Hmm.
So and so in the name of the parents, both father and mother, my lord. your letter number so and so, with reference to your letter on the subject cited above, I am directed to say that the governor of Assam is pleased to recommend for settlement of land measuring 18 lesas covered by Dag number 132 of village Soromoturia under the Beltola Moja with MD so and so and so and so of so and so for the residential purposes, subject to payment of premium of 40% of land value, which has been fixed at rupees 3 lakhs only per kata. The
Okay.
possession of the land may be handed over to the person concerned, and the land records may be corrected and the patta issued after the realization of the premium in full.
Okay,
Uh,
then what happened?
Accordingly, my lord, I have my father's, my lord, my parents deposited this, my lord, premium at page 26 annexure 2. The amount came to be 1,08,000 for 18 lessons, my lord. Accordingly, my lord, a letter has been issued by the deputy commissioner after the premium is paid, addressed to the settlement officer, my lord, is at page 27 regarding land patta. In reference to the marginally noted letter, I most respectfully beg to submit that the governor have recommended for settlement of land measuring 18 lesses covered by so and so at village Moja so and so with MD so and so, subject to the payment of premium of rupees 40% land value fixed at rupees 3 lakhs per kata. Accordingly, MD Kamrul Islam Borhuya by the treasury officer Salan number had paid an amount of rupees so and so in the bank towards the premium of the land. Hence, you are requested to complete all the necessary correction of land records after handing over the possession of the said land as shown in the trace map and to hand over the land patta within the stipulated time. A copy of treasury Salan, trace map so and so is herewith for your prompt action. Accordingly, my lord, the matter was resting thereon. Thereafter, my lord, the repetition had been moved before this honorable court, my lord. My
You
lord,
see,
may-
that much of I understood. You see,
My
now
lord.
the government says that it has been reserved for the capital complex.
my lord,
Correct.
my lord,
Now, if that is so, and for that reason it has been cancelled.
my
You
lord.
see, against the same thing, it will come to the order of cancellation of the
Right.
settlement. Is an appeal, appeal lies.
No, my lord, if my lord.
You
is
see, the court can't decide
my
as to whose claim would be better. It is state's claim for the capital complex, or it is your claim for a private settlement.
My lord.
The court has no way to, no measuring yard to
No, my lord,
to see that.
My lord, I have, my lord, with full, my lord, respectful submission, my lord, what I beg to submit, my lord, a settlement which had been issued way back in the year 2006. And that too, there is a mandamus had been issued by this honorable court. My lord, may kindly peruse for a moment the order passed by this
I
honorable
have seen
court.
that sequence. You see, first
Why?
is that the court says that it should be brought to its logical conclusion.
Logical and my lord.
It was not done. You came to the court again. The court says that no, this court is not an executing court, and therefore the matter rests.
No, my lord, the court, there is no any such order, my lord.
Yes. There's somewhere I.
No, that is the order, my lord, which had been passed.
37.
I moved that petition, my lord, that was withdrawn. At page 37, my lord.
Whatever, but
No,
that's
that was
observation.
on, my lord, to file and at that relevant period of time, what was happened, my lord, the present petitioner moved this honorable court, my lord, with a direction to complete the process. As this honorable court held that as already there is a mandamus had been issued, then that should be a contempt petition, not by of a writ petition.
No,
my
whatever
lord.
you see,
My
when
lord,
I
my
read it alone, I don't
My
have so much of time to understand what is
My
there.
lord.
I just give an overview.
No, my lord,
But
with
the
my limited
but the
understanding, I
problem,
am
but the problem is,
my
you
lord.
see, the reason of not entertaining is different. Few days back, in a matter, I had made an observation. You see, what happens is that a letter of allotment is issued,
My
settlement order is issued, then premium is taken, but the land still has not been, the formal mutation has not been made in the
favor
name
of
of
the
the,
allotee.
in the favor of the allotee.
My
Now you see the land remains in the name of the government.
my
And in this case, there's an order that the premium deposited with 12% interest can be refunded. So now you see, the issue is that if I have to adjudicate, I'll have to go back to my own order and say that when there has been no formal settlement, sorry, the final settlement operations, your name was not entertained. Land remains with the government. So that will hit you.
No, my lord, here is a case, my lord, with my limited understanding, what I respectfully beg to submit, my lord. It was a conscious decision on the part of the government. It was a land advisory committee's resolution also was there. That it was a conscious decision on the part of the government that that particular plot of land should be settled with the parents of the petitioner. my lord. Now, my mother has already died and my father is also in a my lord bedridden condition, my lord. He is not, my lord, is not also very sound. That's why, my lord, we as a legaliers, as the sons, my lord, have undertaken. At this moment, my lord, we are also apprehending that we may be evicted at any moment, my lord. That is also a statement we have given, my lord, in our petition.
No, eviction won't take place from a settled land.
No, that is correct, but as the settlement has been cancelled, my lord, by the impugn order. Nowadays, my lordship is well aware, my lord, overnight bulldozer can come and demolish us, my lord. That is we are apprehending, my lord. And my lord, more interestingly, the Dispur Law College, my lord, which is the Dispur Law College, my lord, I have personally visited the place, my lord. It is just nearby, my lord, Dispur Capital Complex. The Dispur Law College is just just nearby the boundary of the present plot of land. Other government establishments are also there, my lord. And other private settlements are also there. Now, why we have been, my lord, targeted? That is also, my lord, no hearing had also been provided to the present petitioners, my lord. At least, my lord.
Yes, Mr. Goswami, what do you say?
Lordship, that order, Lordship, page 40, Lordship. Now, as per factual report submitted to the Circuit Officer Dispur Tribunal, the present land status is the follows. There are 3 numbers of shops and 10 house business running over a plot of land in question as per record. The entire plot of land is reserved as Rajdhani as per record. There are many quarters of GAT department in the vicinity of the plot of land. No any settlement has been made. Obhada said that in that. There is no settlement of Sweat Lodge.
The settlement is there. Order of settlement is there.
But that is there now. There is no settlement of Sweat Lodge. The settlement order was issued in favor of Kamrul Islam, but he's not residing there, Lordship.
Okay, should Mr. A.R. Bhuyan, counsel for the petitioner, Mr. N. Goswami and government advocate appearing for respondent numbers 2 and 3, and Ms. G. Hazarika and for Revenue Department appearing for respondent number 1. Agreed by the recommendation made by the Deputy Commissioner by order dated 19/5/2023, cancel the settlement of the petitioner. The petitioner has filed this writ petition under Article 226 of the Constitution of India. Issue notice including notice of the prayer for interim relief returnable in give a fixed date after reopening. Requisite extra copies of the writ petition is served on State and Department Council in course of the day. Next, as an interim measure, it is provided that in case the competent authority takes up the adjudication of the cancellation of the order of settlement made in favor of the petitioner, right? order passed by the Deputy Secretary of the Government of Assam, Revenue within bracket Settlement, bracket Police Department, dated 3/8/2006. The petitioner would be given an opportunity of hearing.
While
Next, the petitioner shall produce a certified copy of this order to the Commissioner Secretary to the Government of Assam, Revenue and Disaster Management Department, Dispur.
The road may not be evicted.
Will not be evicted unless your settlement is cancelled. Nobody can evict you.
20.
Obliged, highly obliged.
Yes, Mr. Sahu. Yes,
My lord,
against this order passed by the appellate,
if a joint commissioners, GST,
appellate tribunal is not functioning.
not in person. And penalty is imposed illegally. And ITC input tax credits are also disallowed under section 140 subsection 3 clause
Yeah.
4.
My senior is in leg. But your item may be passed over for timing.
Time being. Okay. Just ask him to take instructions as to whether appellate tribunal is not functioning or not.
It's not functioning.
It's okay.
Notified
His
it.
departmental counsel will take an information. Okay.
Good.
I'm not disbelieving you, but give us
21.
better information.
May I please, your lordship?
Yes.
Lordship, I am extremely sorry to say it, lordship. Lordship, there is some typographical error in page number 2, lordship. And we need to be correct it, lordship.
Page number?
Page number 2, lordship,
Okay, there's some
Top of-
typing error.
in the matter of lordship. Lordship can't be adjourned for the day, lordship. Need to be correct.
Okay, the learned counsel for the petitioner submits that there's a typographical error which is crept in the at page 2 of the writ petition. And seeks liberty to make necessary corrections. Most of the correction may be done in the presence of registrar within bracket judicial. Thereafter, the matter will be listed in court.
Monday, lordship.
23.
May I please, your lordship?
Yes,
Lord, the petitioner filed an FIR.
just a moment.
Before the
Just a moment. Mr. Hussain, this is a repetition I will not entertain.
He can't.
154, you have a 156, you have the
156.
liberty of going to the CGM and
CGM.
filing an application.
Yes.
That's there, lordship. So we filed application before the SP also, lordship.
Pardon me?
We approached the SP twice, lordship.
After the SP,
No, you see, SP need not be moved. Once you move the OC, it doesn't register it. You go to the CGM and get your case registered. That is what judgments of
Vasco, Tambe and
Ah.
Takaria Basu.
the Supreme Court and even this court has said.
Yes.
It goes this with liberty to you to approach the jurisdictional magistrate.
This may be disposed of, giving me the liberty to approach the appropriate forum. also.
Heard Mr. M.I. Hussain and counsel for the petitioner and Mr. S. Barwar and the government advocate appearing for the respondents. Next, brother. The petitioner projects that he had filed that she had filed an FIR on 26/1/2023 for some incident which occurred on 25/1/2023 and that the officer in charge of Bilasipara Police Station refused to register the FIR. So, the learned counsel for the petitioner submits that the petitioner moved an application under section 154 within bracket 3 before the Superintendent of Police Dhubri on 9/2/2023.
And 9/3/2020.
Huh?
9/2/23 and 9/3/20.
9/2/2023. Informing the said authority that the officer in charge of Bilasipara Police Station refused to register a case as per the FIR. First off, a reminder. A representation was made on 9/3/2023 before the Superintendent of Police Dhubri. But the FIR was still not registered. And accordingly, the petitioner has approached this court by filing a writ petition in Article 226 of the Constitution of India. Full stop. In the next one. In this regard, the learned government advocate has referred to the case of what are those two cases? Sarkari Vasu and
Sakaria Basu and Sudhi Vaskar Tampe.
Sarkari Vasu. Project that if the officer in charge of the Bilasipara Police Station has not registered a case, a right would be created in favor of the petitioner to move the jurisdictional magistrate. We're filing an application under section 156 within bracket 3 of the Criminal Procedure Code. Next, the court finds merit in the submission made by the learned government advocate, and accordingly, the court is inclined to close this writ petition with liberty to the petitioner to move the jurisdictional magistrate under section 156 within bracket 3 CRPC. By enclosing in such application the copy of FIR and the complaint made twice before the Superintendent of Police Dhubri. Full stop. The petitioner is at liberty to also produce a certified copy of this order while filing his complaint. Full stop. With the aforesaid observation, this writ petition stands closed at the motion stage without issuance of notice on the respondents.
All right.
24.
Hello,
Yes,
the case of the petitioner before a
just a moment. Where is your application which was rejected? Where is that?
You will find at page 78.
78.
At the bottom portion of the side order, your lordship will find operative portion in after paragraph 1 and 2. The conclusion of the input order.
But you see this, what do you call, the respondent authorities, they've given you permission to come again.
But the fact of the matter is that if respondent authority permitted me to come file a liberty fresh, but I will quote the same section. Because in the land and regulation, except 162D, there is no other provision to file a review petition before the state government. If you lordship would go to peruse the 162D of the state regulation, lordship will find the same section is contemplated in the said regulation.
Where is that? 162.
162D of executive instructions.
Yes.
In this section,
That's fine.
yes, at page 185.
185. Yes, Mr. Barua. The secretary doesn't even know the difference between section 162 of the Assam Land and Revenue Regulation and section and instruction 162D of the executive instructions. He doesn't know the difference. I think this matter will have to inform the chief secretary
Serious,
Sure.
I was wondering.
to take classes of this, to send them to Judicial Academy and ask them to learn
Precious time,
162.
precious time has been spent in this.
Yes, even I took some time to understand this.
Even I was wondering, actually trying to grab, actually I took the assistance of the.
No, 162.
You'll, can you ask him orally to do it, or we pass on orders which would amount to give him instructions and it will go against him in his service career.
Very true.
Because if I make a remark, it will go to his service career.
It will be stigmatic, in fact.
It will be stigmatic. You see, you are for revenue. You are for revenue. You see, it's a simple thing. Your principal secretary, revenue and disaster management, does not know the difference of section 162 of the regulation, Assam Land and Revenue Regulation. He does not know the difference between 162 and 162D of what you call executive instructions.
Yes.
He does not know the difference of the provisions.
Lordship, 162C, earlier it has been amended by notification dated 10/4/2018. 162C provides appeal against the order of yes.
And 162D, what is 162D?
162D, Lordship, it is review
Yes.
against the order of the divisional.
So he has gone to review.
Yeah.
Your page 78 says he has filed a review, and 162 is chapter 10. That means chapter 10 is referring to land and revenue regulation. You tell your principal secretary, I'll pass an order but I'll withhold signature till tomorrow morning. If 10:30 tomorrow morning you can't say, then we'll pass an order.
Name has been so much, that's why I'm difficulty to say.
No, now you are knowing it.
That's
Now
not
you're
I
knowing
think.
it, huh?
Last time I.
So you see, I'm passing an order in your presence. I'm withholding signature till tomorrow 10:30 morning. If 10:30 morning he does not recall his order, then the stricture will go against him. It will go in his service ACR
Does it day after tomorrow, does it make good?
day after tomorrow. You just tell him orally, if he does not recall this order, then it will go with his service carrier. It will taint his service carrier.
Yeah.
His future will be doomed. Mr. A. Paul, Learned Counsel for the petitioner. Mr. S. Barwal, Learned Government Advocate appearing for respondent number
I appear for 3, 4, and 5.
3, 4, and 5. And Mr.
I'm
Your name?
one Lordship.
Your name?
As doctor.
As the third and standing counsel for respondent number 1. Next for the Mr. Dattal and standing counsel for respondent number 1 submit that his name be reflected in the cause list. So according to let this matter be listed on day after tomorrow by showing the name of Mr. Datta is standing counsel for respondent number 1 by listing the matter next.
But they have not provided us copy of
Today's proceeding may kindly be recorded 2 sentences.
I am not recording because if I record, it will be detrimental to his career. You give no extra copy. Let him get instructions.
25.
Give it on the service. But tell him over phone. Tell him over phone. If he doesn't understand, then my strictures will affect him. Yes, Mr. Sharma.
Yes, wait, please. Also, the petitioner is a social activist who had lodged certain complaints before the respondent number 5. The lordship would kindly come to page 23, annexure 1. That was the first complaint that he had lodged regarding officials of the respondent organization with respondent number 5. Respondent number 5 being the chief vigilance
Now
officer.
just tell me whether this person has filed any other previous complaint, because the complaint of this nature I have seen earlier. Mr. Parashar, you remember?
My lord,
You recollect.
I have searched my lord, this by this petitioner's name, my lord, I have found my lord, one case is still pending on the WBC. But I have not appeared, my lord, but I have found one case again, my lord.
No, but a similar nature of complaint we have, I have seemed to have read it. Are you sure no other complaints have, no other representation has been filed?
No. This is the only one. Yeah. In fact, there was another matter regarding withdrawal of his PSOs at a later point in time. That's 2 years.
No, no, no,
This is the only matter.
No. Complaint of this nature.
Yes. The issue that has arisen in your lordship is that the subjects that complain.
Who are you?
I'm a social activist, your lordship. I'm an investigative journalist, your lordship. My cause of action arises by annexure number 3, page 40. If your lordship comes to page 40, your lordship would see that it sought to authenticate my identity. It sought to authenticate my identity. But I've gone through the CVC Act, which talks about the Central Vigilance Commissioner. Phone number 5 is the Chief Vigilance Commissioner, your lordship, which I've found from the internet.
the appointment and the responsibilities. The duties of respondent number 5 is to look into the complaints received after authentication of the complainant into the functioning of the respondent organization. The initial complaint was filed in the month of July. And thereafter, the subject in those complaints were bestowed with the post of technical director with the respondent organization. Eventually, now what has happened, your lordship will kindly come to page 54 for a moment. Your lordship. Page 54. Page 54 is the complaint lodged before the Central Vigilance Commission against respondent number 5 now for revealing perks and facilities which is not entitled to. The idea for the CBC is to remain neutral, unbiased, and to look into complaints and matters of corruption. This has occasioned this instant repetition for this honorable court. To satisfy the court, we have attached the attachments also, which shows that respondent number 5 has been availing perks and facilities which is not warranted by the post that he holds. Thereafter, the petitioner was constrained to prefer an application before respondent number 2 and respondent number 4 separately. Now, both those sets of complaints have not been dealt with. There's an apprehension, the respondent number 5 in his capacity in disposing of the complaints which was filed before him by the complainant. That is the crux of the matter, Your Lordship.
We'll still dismiss your writ petition and provide you that if you are still aggrieved, you go to the Chief Judicial Magistrate, lodge a complaint. Because you see, your duty is to file a complaint.
Yes,
If the authorities don't take cognizance of it,
yes.
you have a regular court where you can file a complaint.
But there's a mechanism which is entrusted under law, Your Lordship.
It's okay, you can still move it. But nothing more, the High Court will not put a pressure on the officers to have this matter investigated.
The only protection we seek from this honorable court, subject to Your Lordship's interference, is the fact that the respondent number 5 did not act upon the complaints which were received by him. The only reason.
It's okay.
Yes.
You see, we get in course of my work, I get a lot of complaints from every quarter.
Yes.
Correct.
Yes.
Not even that. I hear I even hear gossip of a matter when it is adverse to the lawyer. In the trial courts, we always find a gossip in the corridor there. This magistrate does not know anything. This magistrate has been won over. This magistrate is corrupt. This magistrate that. It's a usual gossip we hear when I was earlier a lawyer.
Yes. So, but if I may permit to draw a difference, Your Lordship, the fact of the matter in this matter is that looking into grievances of the parent organization is a duty which is entrusted the CBC. Unlike
It's okay. You lodge a complaint.
the complaint has been lodged before the authorities, Your Lordship.
If they don't work, we can't do anything. Supreme Court says that your right is accrued to file a complaint under 156(3).
In fact, Your Lordship, there is a complaint which is pending before respondent number 4, which is the Chief Vigilance Officer of the Ministry of Petroleum and Gas. So we do not seek to expedite the response from that complaint. What we are seeking now as an immediate measure, Your Lordship, is that respondent number 5 do not act on the complaints that we filed in the month of July, because that might have an effect of reducing the disposal of the complaints. Because now he himself is a party to the complaint made before respondent number 4. That Your Lordship would see, we have substantiated that for Your Lordship's convenience with attachments which prove that it goes squarely against the circular which is at page 72. Prima facie, Your Lordship, to satisfy this Lordship, Your Lordship.
Page 72.
Page 72 is the circular which respondent number 5 has flouted and which has been annexed at page number 54. To satisfy this court prima facie, Your Lordship. We have very limited prayer.
You see, insofar as the proceedings of a Central Vigilance Commission,
Yes.
can you show me any authority that the High Court can monitor and review its what you call its the progress of investigation by a CVC?
We do not seek to stall or affect the investigation by respondent number 4. All we are asking for. a limited
It's okay. You
yes,
see,
sir.
what does the magistrate do under 156(3)? It has the power, three powers he has. The magistrate has. Number one, to see that the case is registered and investigated by the police. Number one. Number two is that the court has the power to monitor the progress of the investigation. And the third is what do you call three propositions. I forgot the third. So the three propositions are there when the magistrate deals with the with these matters. Correct. So third one I forgot. I don't know. Now the question is that the High Court, unless it sees a reason under 226 to monitor a particular what you call investigation,
Yes.
like say supposing for example death of a prisoner or army killing by the armed forces of some citizen.
Yes.
Those things the High Court can monitor, and the Supreme Court has permitted the High Court to monitor such cases. So therefore, I'm asking you, in a complaint made before the CVC, is there any authority which says that the CVC, progress of the CVC investigation can also be monitored by the High Court?
No, I in fact have gone through the rules and the act, in fact, your lordship, there is nothing onto it.
No, it will not be in the Act.
Yes.
Act, even the CRPC does not say that the High Court will monitor it,
Yes.
but we are doing it because the authorities, there are authorities on the point.
Yes.
Now, in case of CVC, is there any such authority on where it has been held?
Not aware of that. In fact, my lordship will grant me one more day's leave to satisfy this court if there is an authority. Otherwise,
Well, if there is a complaint, then the best option is that you permit you to file
I'm not seeking a lordship's indulgence to affect or stall the process as such. What I'm praying for, a limited prayer in this matter, your lordship, is that let respondent number 4, which is the chief vigilance officer of the MOP, carry out his complaint against respondent number 5. And till then, a basic blanket cover of respondent number 5 not dealing with the complaints of respondent of the petition.
No.
That is all.
You see, we are very cautious on doing it because this will be taken as a direction of the court to investigate when
Yes.
where there is none.
As per section 15 of the Central Vigilance Commission Act, no prosecution shall lie against the CVC. As per section 15, I have given on printout.
It's okay, we'll give him time. You satisfy us on day after
Yes,
tomorrow.
yes, definitely.
Because CVC, we are not directing. To take
2, 3 and
steps.
4, section 15 of the
Yes,
no suit prosecution or legal proceedings shall lie against the commissioner, vigilance commission, and any other secretary.
no, this is not a prosecution.
Yes.
He's just wanting to move the authorities to have the investigation done. We are giving you back this. Book of Mr. M. Sharma, counsel for the petitioner. So, place for adjournment. Mr. K. Parashar and CVC is present. List one, day after tomorrow. It will be
9, madam.
for 12, many cases are there. My court master says Monday, 15th. Sorry, 12th.
20.
Yes, Mr. Kyal, appellate authority is not there.
Yes, lordship, lordship can entertain, but lordship on merit. Their contention is that the provision is bad. If that is so, they could have preferred challenge that particular provision, lordship. Lordship is pleased to come
No,
to.
no, he's not wanting any relief on that one.
No,
He
no,
just said that the provisions of 16 read with 140 has been violated. That is what he says.
No, lordship, may pleased to see. Lordship may pleased to see page 89.
Page,
Page 89, paragraph 7 of the clear cover report. Page 89.
just a moment.
Many writ petition has been filed challenging the aforesaid provision laws.
Just a moment.
Paragraph 7. Lord.
Just one.
So go. It's
Page
page 89. Lord.
89. Yes,
I find that it was the allegation of in the SOCOS notice issued to the appellant authority that the appellant had availed the utilized self-assessed ITC in tranche 1 to the tune of rupees 20 lakh 69,000 so in violation of section 140 and section 16(2) of the CGST Act 2017, where with rule 636(1) of the CGST rule 2017, the following if the submission made by the appellant in response to the SOCOS notice, the executing authority held that while the amount of rupees 15 lakh 16,000 was found to be eligible to the appellant as transitional credit as per the section 140(3) of the CGST Act, the amount of rupees 5 lakh 53,180 was found to be have been availed in violation of section 140 subclause 3, an explanation to section 140 CGST Act 2017, as some of the transitional credit were availed against the invoice which were issued prior to 1/7/2016.
समझ इसी बोल रहा है Yes,
Lordship, I am reading page 90, Lordship.
yes, I'm there.
Explanation to section 140 CGST. As some of the transitional credit were availed against the invoice which were issued prior to 1/7/2016, and the same other transitional credit pertains to the payment made as central sales tax CGST. The executing authority thereby dropped the demand of rupees 15 lakh 16,000, but confirmed the demand of amount of rupees 5 lakh 53,000 under section 73(1) of the CGST is the applicable interest. Now, Lordship, may come to page 91. Because provision is there and the department is to comply with unless these provisions are there in the statute laws. Lordship, page 91.
You see, Mr. Carroll,
Lordship.
I'm only going by the prayer made as page 54.
Lordship.
Here they say that the demand which was confirmed in the order in appeal, in the original order in original
Yes, sir.
is not sustainable. And he says that there should be a direction for this grade of adjustment of excess tax input. Credit. So
I understand, Lordship, their prayer, but what is the basis of their prayer? Because there is
whatever we, but if the appellate authority is not there, what we can do?
no, Lordship. Lordship, what is their contention, Lordship? This provision is illegal and Article 14 has been violated. Since the provision is there, Lordship, the department is bound to follow the provision, Lordship. And their import trades credit was disallowed because it was prior to 1/7/2017, Lordship. And the provision is there till it is.
No, you see, it may be violative of Article 14. Ipso facto doesn't make the provision ultra virus.
No, their contention is there that this is in violation of Article 14.
So Article 14 is equality.
And yes, Lordship. And
It doesn't say that it is
Six.
otherwise the constitution.
No, Lordship, section 16(2) and 16(4) has been put under challenge before the Honorable Court also, Lordship. Number of writ petitions are pending, Lordship,
Okay.
on availment of ITC, Lordship. One batch of writ petition where they challenge the section 16(2) and 3, and in what writ petition section 16(4) has been challenged, but no stay has been granted, Lordship. Here the mere contention, Lordship, my submission, when there is a provision is there, and the authority has acted on that provision, unless that provision is set,
No, I could have heard you, but I don't have time today.
Lordship, a fixed on some other day, Lordship, I'll satisfy you, Lordship.
We'll ensure short notice then.
On Monday, Lordship,
Monday, okay.
Lordship. I'll satisfy you, Lordship.
Instead of Monday, we are making it Wednesday, next Wednesday.
Lordship. Yes, guys.
We'll hear you on that that issue. I'll issue a notice and then 17th in admission. We'll try to finish it off. But Mr. D. Saura and counsel for the petitioner and Mr. S.C. Kyal and the study counsel for the
Yes,
respondent numbers
CGS.
respondent numbers,
Lordship, respondent numbers. I can represent all.
all
Lordship.
for all the respondents. Next paragraph. At the outset, the Leonard study council for the respondents submits that is ready for the hearing on merit of the matter. First stop. In that, in view of the said submissions, comma, and considering that the appellate authority for what is it called? Appellate authority? What is the name? Appellate authority.
Tribunal, Lordship, it's under section 122.
So what is it called?
Joint Commissioner Appeals, Joint Commissioner Appeals, CGST.
Joint Commissioner, no, Joint Commissioner is there. The appellate tribunal, what is the name? Appellate authority.
Tax Tribunal.
As a tax tribunal is presently not functioning. I issue notice of motion.
Not appointed, Lordship. Till date, no tribunal has been appointed.
So no tribunal has been constituted.
Yes, constituted.
Constituted. I issue notice of motion returnable on 14/6/2023. Liberty is granted to the respondents to file their affidavit in opposition if so desired. This is the admission column on 14/6/2023. Mr. Kyal,
Lordship.
I would also require your some clarification I want to have. There's a
Lordship.
matter I found it.
Item 70, Lordship.
No. 3 days back, I heard the matter. I still have some confusion. I have to ask you.
Lordship,
For
that
clarification.
council from Bombay, this year, Lordship. Two petition, Lordship.
No, I don't remember which one, but I have noted the query.
Lordship.
Immediately after I rise, because at 4:30 I have a meeting. So I rise 2 or 3 minutes earlier. So this will take me 2 minutes to
Lordship.
converse with you.
Production list item number 1. May it please your lordships. May I refer to the earlier order of this honorable court, the 29th of May.
Yes.
But this was the case where alleging irregularities in the voter list of the AGM election of particular society, shareholder had proposed his honorable court. Thereafter, this honorable court directed that since election is so near, go ahead, but submit a representation. They do not give approval to the result of the election. Things went so fine. Suddenly, someone saw it.
I remember that. I'm just
And
reading
the
your, reading your amended prayer.
My lordship. It's
No,
exactly as was allowed.
Okay. Yes, Mr. Taradar, what do you have to say?
Well, in fact, I have 2 submissions. Firstly, the question is whether, I'm wondering whether it's about the case of a judicial sanctity. Because virtually, when there is a direction which has attained finality, whether it can be tinkered with.
No, this is not tinkering.
Please explain, I didn't follow you.
In fact, there was an application for withdrawal. But what I say, the honorable court has directed, on certain findings for adjudication, whether that can be allowed to withdraw. My submission is because the power under the Act, Section 41, the registrar is the final authority. Even in absence of an application, he can exercise the suo motu power. In fact, I wanted to check, from the in the Act there is no such specific power. But reading General Clauses Act, Section 14, with Section 41, perhaps that suo motu power can be inferred, because Section 14 of the General Clauses Act says
No,
where
you see, we can extend that thought in a different way. Now, you see, there are certain offenses under the CRPC which are compoundable. Certain offenses under the IPC or under the special laws are non-compoundable. Correct.
Correct.
So now somebody came to this court, got an order of an investigation being done.
Yes.
inquiry, hearing being done on a particular what do you call this election, the manner of which election was held. Now, at the end, he withdraws it. Mr. Banik says that he has been won over.
No. That was not my case. What I said is that
No.
he had not filed an application after election. He had filed the case with petition prior to the election, alleging irregularities. Since the time was too close and the jurisdictional authority was the registrar concerned, therefore this honorable acted in favor of the writ petitioner, said you go ahead. Election could be held. But registrar not to give
Irrespective
approval.
of well, the merit of this case, irrespective, I am not on the case, my lord. What I am on, well, perhaps it may become a judicial precedent, my lord. I am on the sanctity of the honorable court's order.
He's supporting me. on that.
What I am on, my lord, that perhaps your lordship may not allow. Because even the my lord, registrar has a my lord, so much power, reading section 41, my lord, with section 14 of the General Clauses Act. I am on that, my lord. Because if it operates as a precedent, my lord, then it may have a cascading effect. It will have some ramification, my lord. I am on that. Because if under the rules, my lord, it is the registrar. Under the act, my lord, it is also the registrar, who is the ultimate authority, my lord.
Then I issue a notice on this.
My
I
lordship,
leave it to
let me
you.
say the other way around. When the order dated 29/5/2023 was passed, after much deliberation in this honorable court, this order was inconsistent. When we were all one on it, and therefore, without rejecting my prayer, then this liberty was given to amend. I so amended the writ petition with the prayer, brought it before. Now, a different but sweet argument has been taken up that this would have a cascading effect.
Or
But
order
a
has been passed
cascading effect
already, my
is
lord.
separate issue altogether. What I am on is, lordship may issue notice, but the end result would be, yes, whatever to be the, I cannot hold it back, my lord. So far as the Honorable High Court's order, the first order was there. That was an order in rem. He agrees to it. It's an order in rem. And the adjudication, the order to follow, would also be an order in rem. That also he agrees to it.
Registrar has
The
already
only
passed an
person
order,
on party is that the person wants to submit a representation, which he did or he did not. Regardless of that, since I say he was smart enough, the gentleman was smart enough to make this move. Well, I come to this honorable to say, kindly, regardless of his withdrawal, let there be an adjudication. This part, honorable court had already allowed.
But
What-
why you are arguing when I am issuing a notice?
But I needed some protection would be there because the last order was that, my lord, the amendment shall be done in presence of the registrar, so and so, so and so, my lord. If I may read the order, the last order of the honorable court
Yes.
is submitted to respond number 5 after obtaining order dated 8523 in so and so, has withdrawn the original complaint filed before the registrar of so and so, which was not anticipated and accordingly dislodged the petitioner. Accordingly, learned counsel for the petitioner prays for permitting him to amend the prayer in his petition so to enable him to pursue the complaint 35. If even now, otherwise in the between some order has come that since he has withdrawn, they have to give the approval. If now he proceeds with that complaint, what we had filed, Annexure E, then also time is saved. Lordship may dispose of the writ petition. That would be,
The motion say I am not disposing it of.
but then some protection, my lord. If otherwise notice of motion is issued and they give approval to the body and the body starts functioning, then the writ petition goes. That was exactly what I was submitting the other day.
Okay. How this has Banik counsel to the petitioner and Mr. S.K. Talukdar and its standing for respondent numbers 1 to 4. Issue notice of motion. Including notice on the prayer for interim relief returnable on so and so. After vacation. Because the extra copies of the petition be served on the Learned Departmental Counsel in course of the day. The petition shall take steps within 2 days for service of notice on respond number 5 by registered post with AD. To stop. Next for the heard both sides on the prayer for interim relief. Post of the learned counsel for the petitioner. Submits that the respondent number 5 had obtained an order dated 8/5/2023 by this court in WBC 2439 of 2023. But thereafter withdraw his original complaint against the election held for the managing committee of Gandhigram Samabay Samiti Limited,
Karimganj.
Karimganj. Full stop. Accordingly, they submitted that in the event an interim ex parte interim is not passed, comma, sorry, if an interim protection is not granted, comma, don't add ex parte, is not granted, comma, there's every likelihood that the competent authorities in the corporation department would grant approval to the managing committee of the said cooperative society. On a pointed query of the court, comma, the Learned Standing Council for the Corporation Department has submitted that even otherwise on a election complaint, comma, the Registrar of Cooperative Societies has so much of power to make inquiry if there is any illegality, to find out if there is any irregularity in the conduct of elections. Full stop. In that view of the matter, comma, the court is inclined to provide that there is an interim measure until the next returnable date, comma, the respondent numbers 2 and 3 shall not grant approval to the managing committee, the newly elected managing committee of Gandhigram Samabay Samiti Limited, Karimganj.
Well, rather, your lordship will say, as the honorable court said earlier, the departmental officer will run the society. That will be more
Okay,
better.
okay, all right.
Oh, okay.
I consider-
Until then the until further orders, comma, the it would be open to the respondent number 3, namely Assistant Registrar of Cooperative Societies.
RK Nagar
Karimganj.
Karimganj, my lord. It should be RK Nagar Karimganj.
Acha, RK Nagar Karimganj.
Right.
To appoint a
But in fact, it will be appointed by 2 men. It can be
by
appointed.
2, okay.
My lord.
Okay, so
Registrar of Cooperative.
not Assistant Registrar, make it Registrar of Cooperative Societies, Assam, shall appoint a
Departmental officer or 1-man committee.
department officer of the one-man committee to manage the affairs of the said society.
Well.
Next, the petitioner shall produce a certified copy of this order before the respondent number 2
Well.
to bring it to the notice of the said authority.
Well,
Yes,
that
yes, yes.
respondent 3, he should be ARCS RK Nagar Karimganj.
Next one. At this stage, the Learned Standing Council for the Corporation Department submits that the correct nomenclature of respondent number 3 would be Assistant Registrar of Cooperative Societies,
RK Nagar
RK
Karimganj.
Nagar Karimganj.
My lord.
Of the Learned Council for the petitioner shall take note of the same and give the needful.
Obliged.
21-7.
Just a moment. Okay, my court counsel says that the petition person is there in item 38. Which is that? Yeah, there.
Lordship, this is
So you see Harish Gupta is here.
he was here only.
Let's wait for some time then.
Oh.
Let's wait for some time. Yes, 26. Yes,
Petitioner, your lordship, in this matter, the supply materials for implementation of MG Enrega scheme, your lordship. The bill has not been paid. In a similar matter, your lordship.
Yes.
similar,
What do you say?
matter, Your lordship has already disposed of.
We have received some instructions from the video.
yes.
For some technical problems, the number of the scheme, construction of the CC road from the starts from bypass road towards Samsuddin House with guardrail in Naranpur to under MGNREGS for the year 2016-17 could not be generated, for which the payment could not be released. So the matter is pending before the higher authority. So lordship need 3 weeks time for taking instructions from the higher.
Lordship, kindly page.
Direct them to do it within a time bound period. We'll give them 3 months time, why 3 weeks? But they have to, this matter can't be kept pending for just for that.
In a similar nature case, your lordship has disposed of the.
Let me see. Seven years technical reason. 2000s, what is the period of that work?
16, 17.
16, 17. 17 went to the, how many years? 5, 6 years. Technical difficulty.
Page 52, may I please? Sorry.
Just make necessary corrections because won't have time to do. This work orders and all. The supply loading, uploading of supply bills. Make those corrections and give to the report master in this order. Your name was?
And Bora.
And N. Bora. So government will be appearing, Bora. Just make these corrections.
For decision for an appointment of an arbitrator. But on the last occasion, my lord, the honorable court has.
So what is the date when you finish the work? Contract agreement of 88, 89, 90.
But
So when did you finish it?
we have finished it in about 94 lots of.
So it will be barred by limitation. Question of limitation can still be gone into while appointing an arbitrator.
No, my lord, initially, my lord will, there was page 5.
There was
No,
appointment
just-
of arbitrator earlier also. And that arbitrator has given the ex parte decision which was dismissed by this honorable court. I have enclosed it here only, page number 5, Lordship, 5 to 7. Recently, the ex parte award has been set aside by this honorable court on 11/8 to 2022.
Well, initially an ex parte award was passed, which was challenged in the section 37, page 11, my lord.
Just a moment. So we'll appoint an arbitrator then. We'll appoint an arbitrator.
My lord. The question of arbitrability, my lord, that will maybe left open for the arbitrator to decide,
That will have to raise the objection before them.
my lord. I have given a notification, my lord, from the list, my lord, there is a high court notification.
We'll appoint Justice, Honorable Justice C.R. Sharma.
My lord.
So that should may submit one submission. That should be another case. The court number 2 has already appointed arbitrator. One of the arbitrator was just the honorable court, that is senior counsel. But her name was not in the list of notification issued by the High Court. Even then, the court had appointed arbitrator saying that she is the member of the Indian Council of Arbitration. That I have already brought it in the record.
No, maybe that-
Kindly that if kindly appointed that, because she is very much familiar with the terms and conditions policy of the respondent department. This is my submission.
No. We will appoint either if you want a former honorable judge of this court, or if you want retired district and session judge, you can appoint on these 2 categories. But not somebody which is not in the.
Then Lordship, then this is the engineering matter. Kindly appoint of this item number 50 in the list of that Sri Engineer Jaidev Goswami. He is the engineer, at least engineering matter can be seen by her.
Yes.
My lord.
Harshi Ghanshyam Das Dhiman, partner of Mrs. SR Construction, who is appearing in person, and Mr. Harish Gupta and CC appearing for the respondents. Next one, this is an application under section 11 within bracket 6 of the Arbitration and Conciliation Act, 1996 for appointment of an arbitrator. This one. It is projected that the petitioner, the petitioner's firm was awarded with a contract for which a contract agreement number, capital CWE, public TEZ, public 39 of 1980-90 was executed where is that agreement?
No, there is not an agreement is not here, Lord.
If agreement is not, I can't, I won't have the jurisdiction to do anything.
That I'm having, Lord. This is a page number 15, Lord. 15.
Page number 15.
15. That comes in arbitration clause, Lord.
No, you have to produce the entire agreement. You can't give a separate page.
Lord, this is entire every agreement, other part of the agreement is only technical matter, engineering matter. This is the only law matter.
The requirement is that the court must peruse the entire the agreement. That is the legal requirement. If you don't do it, we don't pass on your orders. The entire contractual agreement is not on record. The petitioner shall produce the same by filing an additional affidavit. When do you want?
Lordship, next week, Lord.
Okay,
Wednesday, Thursday.
based on 14/6/2023.
Lord, only.
27 to 31.
Lordship, in item number 27 to 31 are similar, Lordship. In 28, we have filed the affidavit, Lordship. For other cases, that has been sent for vetting, Lordship. So it will be for 2 weeks' time, Lordship, for the Union of India, Lordship. In one item, we have filed the affidavit.
Okay,
Only date may be fixed, man.
okay. When do you want?
2 weeks.
After 2 weeks, Lordship.
Give a date. Mr. NNB Chaudhary
Yes, man.
wants a date.
27, 27, 21, 23, no?
23.
Minus 26, 26. Let it be 26, Lordship.
Yes, man.
No, 26th, I'm not fixing any matter, just before the vacation, 23rd.
27.
All sides, including Mr. B, including Mr. NNB Chaudhary, done
Additional approval.
additional advocate general for
Respondent number 4.
the state of Arunachal Pradesh is present. On the prayer made by Mr. B. Chakravarti on CGC, based on 23/6/2023, so as to enable the
Union of India.
the Union of India to file their affidavit in opposition in which writ petitions?
Except 28, Lordship, we have filed, in 28, we have filed. Rest of them,
we have filed one.
27, 29, 30, 31.
20,
27, 29, 30, 31.
27,
29, 30.
29, 30, 31. This 4 representation you want to file.
I
This-
already filed the affidavit.
Oh, okay, the Learned Additional Advocate General submits that here the state of Arunachal Pradesh has already filed the affidavit. Based on so.
In this case, below poverty line, Prime Minister's Gramin Awas Yojana Gramin beneficiary, his name was in the list of beneficiaries, page number 13, serial number 60. What happened, my lord, in this list, the petitioner's mother was a widow and her name was also selected and according
No,
to
but you see, your mother got a house, you will not be entitled to that benefit again.
that was my lord in the name of the mother, my lord, and which is my, I have mentioned in paragraph number 5, I have 2 sisters. And the
No, where is the statement that your mother has not, what you call, given you any share in the property? You have lost any share, all the share in the property.
I have mentioned in paragraph number 5, my
You
lord.
see, once you are a legatee,
Yeah.
in under the Mohammedan law,
Yes,
you are a sharer.
yes.
You can't get a second house.
But my lord, I have 2 sisters, my lord. The sisters.
Your
claiming-
sisters will take care of themselves. Don't worry.
Yes, I have mentioned paragraph 5, my lord.
This is the, have you stated anywhere that your writ petition is for, what you call your sisters? There is not a statement here. This is not a representative capacity writ petition.
No, paragraph 5, I have mentioned that my sisters now claiming the house, my lord. Paragraph number 5, my.
You file a suit against them.
lord.
fact,
They
my
are
lord.
equally, they are equally entitled, my lord.
Correct. You file a suit against them. You
In
decide
fact,
your share.
May I add one more, in fact, in her mother's, my lord, the scheme, my lord, his petitioner's account was used, my lord, to receive the amount, my lord.
After death, my lord.
You will dismiss this, Mr. Kadir. This can't be allowed.
My lord, similar cases, my lord, they have considered, my lord, I have mentioned paragraph number 10, my lord, kindly, my lord, for a moment. my lord.
No, one mistake somewhere will not entitle you to the same mistake again.
So, my lord, they did not file any affidavit, my lord, on this, my lord, for that. The other persons, my lord, similarly situated, my lord, have given the, in their own name.
No, you see, this is something which the court can also take cognizance. You see, somebody, one negative, what you call, negative equality principle will not apply in such cases. You show under the scheme that when your mother has got it, then you are entitled to a house. If you can show that, it is okay. If your sister makes a claim, you have 2 options. Number 1, not to deny her. And this there, your sisters will file a suit. The second alternative is that you file a suit that the sister don't have a share. I can
They
only,
have shares, my lord.
no, we don't know. Your sister may have a share, may have relinquished her share, we don't know.
In fact, one affidavit has been filed, my lord, on 2/9/22 by respondent number 7, my lord. In paragraph 6, my lord,
Who is respondent was
is
7?
the chairman, my lord,
Okay.
the president. Filed on 2/9/22 by one Roop Nehar Begum Mazumdar.
I've seen that para 9, 8 I have read.
Para 6 is also there, my lord,
Para 8 I have read.
my lord. And he admitted in, petitioner admitted in paragraph 5 that he is residing with the mother, my lord.
Not with the mother, my lord. The house allotted to the mother, my lord. Mother expired, my lord, not with the mother, my lord. And now, my lord, the problem is the sisters claiming the house, my lord, that it was. allotted in
Paragraph
their-
5 of the writ petition, my lord,
Correct. But they have a wonderful lawyer for them.
7th line.
This petitioner is a wonderful lawyer for them. He'll advise what to do when sisters make a claim.
It is the fact, my lord, I have
No,
mentioned.
that's what I am saying, but I am appreciating your appearance.
He has, my lord, his own
No, Mr. Gandhi, this is something will not permit.
children, my lord, and they are claiming, my lord,
No,
so
no.
for him, my lord, it was not possible to
Had
decide.
Mr. M.J. Kadir learned counsel for the petitioner. And Mr.
Let the
S.
department decide, my lord.
will not permit that. And Mr. S. Datta learned standing counsel for the Panchayat department, the PNRD department, appearing for all the. for the
1 to 4,
respondent
5
numbers.
and 6, well.
1 to 6.
1, 2, 4, 5 and 6.
So 1, 2, 4, 5 and 6. And Mr. N. Rushavir and government advocate appearing for respondent number 3. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for a direction upon the respondent authorities to include his name in the list of beneficiaries for sanction of PMAY-G house under Hathikal, HATI-KHAL, Gaon Panchayat, under Sonai Development Block. First of all, the case of the petitioner, in brief, is that he is a person from socio-economically weaker group. And initially his name was included in the socio-economic and caste census from 2011, which entitled him to have his name entered in the PMAY-G beneficiary for the Hathikal Gaon Panchayat. And his name was entered at serial number 60, by ID number 2004738. First off, the petitioner approached the authorities on several occasions, but his name was not entered in the beneficiary list. And later on, he came to know that the name of the petitioner was deleted from the list of beneficiaries. First off, the petitioner submitted a complaint on 5/7/2021 before the respondent number 4. Which remained unresponded. Hence this petition. First off, the learned counsel for the petitioner has submitted that PMAY-D house was allotted to his mother. But the petitioner has 2 sisters who have staked claim on the house of the mother in exclusion to the petitioner. And therefore, it is required that the petitioner be also provided with a PMAY-G house. Next para. Per contra, the learned standing also for the Panchayat and Rural Development Department has referred to statement made in paragraph 6 and 8 of the affidavit in opposition filed by respondent number 7 to project that the petitioner's mother was allotted a Pakka house under the PMAY-G scheme, and that payment towards the same was routed through the account of the petitioner. First off, it is also submitted that some other persons may have got the benefits of allotment of PMAY-G house despite their family members being allotted a house, but if that has happened, it is a error on part of the authorities, which should not create any legal right to the petitioner to have a PMAYG house when such a house was allotted to in the name of his mother. Next para. Having regard to the undisputed fact that the mother of the petitioner, namely, her name is there.
Serial number 5, my lord.
So what is the name? Oh, what is the name?
My lord, I'm giving my.
There is not, my lord, mentioned, my lord.
That's Timothy.
Amina Khatun Borbia.
What is the name? Please repeat again. Amina Khatun Babia.
Amina Khatun
Okay,
Borbia.
so Amina AMINA Khatun KHATUN Babia BHUIYA was included in the list of beneficiary by serial number 005 with ID number 1699574. Full stop. The money for PMAY-G house was sanctioned in favor of the mother of the petitioner in the year 2016-17. Full stop. Under such circumstances, the petitioner is miserably failed to show that under the appropriate scheme, the petitioner would be entitled to PMAY-G house when one such house was sanctioned and provided to the mother of the petitioner. Next paragraph. There's nothing, there's no material on record to show that in the event after sanction of a PMAY-G house, there is a dispute between the family, within the members of the family, each member of the family would be entitled to a separate PMAY-G house. Under such circumstances, as there is nothing on record to show that the petitioner has been separated from his extended family, including his mother and sisters. The court finds no merit in the petition and the same is dismissed. Next paragraph. Insofar as if any other person has received a PMAY-G house despite his immediate family members, like parents or children, being allotted such a house, it would be such allotment would not be strictly in terms of the scheme of the PMAY-G, and therefore the court is of the considered opinion that the right to negative equality, or the principle of right to negative equality would set in and would dissuade the petitioner, would dissuade the court from granting such benefit to the petitioner, as it would lead to granting of seal of approval to an illegal act. Accordingly, this repression stands dismissed. Parties are left to bear their own cost.
Obliged.
Lordship, in item number 27 to 31, there was an interim order that may be continued, Lordship. Obliged, Lordship.
Yes, 33.
Yes. Matter
Yes.
relates to my lord,
Mr. Hussain.
non-payment of rectification bill on last occasion. My learned fund was directed to take its after that instruction.
Rectification of
Non-payment of hiring bills.
oh, hiring bills. Okay, okay, okay. Yes,
The instruction law, they admitted that.
should give them a direction to make payment in 3 months.
They will verify law. They will verify.
They will verify, yes, okay. Non-payment of vehicle hiring charges. Mr. A.K. Hussain, and counsel for the petitioner, and Mr. N. Goswami, and government advocate appearing for the respondents.
I'll
Okay.
say for respondent number 2, my lord.
Then Mr. Goswami, you for respondent numbers?
1, 3, 4, 5, 6, and 7. Lord.
Okay, except 2, 1 to 7, huh?
Lots.
And for 2, Mr. Shalial, and standing counsel for revenue, for finance department. Agree by non-payment of the vehicle hire charges amounting to rupees 7,16,223 for the period from 12/6/2019 to 30/4/2022 by whom?
Respondent number 5.
By the Superintendent of Police Hujai, within bracket respondent of 5. The present writ petition has been filed under Article 226 of the Constitution of India. Full stop. In this case, in this case, a notice of motion was issued by order dated 10/6/2022. Until date, no. Until date, the respondents have not denied their liability. First of all, under such circumstances, the court is inclined to provide that the respondent number 5, i.e. the Superintendent of Police Hujai.
Actually, madam, respondent number 3 is to normally pay. Madam.
Huh?
3, madam. 3 may be given.
Who?
4 may be given direction. Assistant Inspector General of Police.
No, the inquiry will be by number 3 only,
Lordship, they
by
have
number
forwarded,
5.
they have forwarded the bill to the headquarters, Lordship, by the SP.
That is the last instruction was there. That is why as per earlier order, madam, it was.
So verification who will do? Superintendent of Police will take the vehicle on hire and inquiry will be done by the DGP.
Oh.
Then,
But no instruction, Lordship, all the higher charges bills already sent to Assam Police.
it is okay, but verification, somebody must verify and say that this is correct.
Earlier occasion,
You see, all bills forwarded. Can you say that your officers were forwarding the bills? They are to be taken as correct for granted. You are also saying that verification is to be made. I'm just asking who will make that verification?
similar.
Because you see, this court staff, I wanted in the morning a pencil. He got to the went to the market and got me a pencil. Correct. He says that it is 5 rupees. So he has got me and taken the money from the court master. 5 rupees he has taken. Now verification, I'll ask the Registrar General to do it. I'm just asking you, I'm trying to understand in police who will do the verification. Tell me the authority will direct him.
SP, Lordship.
Because you took that objection, you have to tell me who is to do that verification. Because in my understanding, I found that if I ask the Director General to do the verification, that would be too cumbersome for him.
Actually, madam, on the last occasion, madam, the respondent instruction, my lord, it was done by the SCP and forwarded to the respondent number 4. Now, that is why the up-to-date instruction was sought for from the respondent number 4. Perhaps order is there. Yes,
Doesn't say up-to-date instructions only. Will give is not there.
right, it was the Assistant Inspector General.
Okay, at the discretion of the authorities in the Assam Police, it would be open to the respondent 5 or any other authority in the Assam Police to verify the correctness of the bills submitted by the petitioner and release the payment within an outer period of 3 months from the date of service of certified copy of this order by the petitioner before the Assistant Inspector General of Police within bracket A, bracket close Assam, within bracket respondent number 4.
The 34 is also same. Similar.
34 is same.
Same,
Okay,
only amount is different.
okay. Just write in a piece of paper the amount to the court master.
Mal,
Write and give it to him.
mal. It is 11 lakhs.
Just write and give it.
What?
Yeah. So then I will not oppose the brief.
Hello.
35, yes.
In this case, my lord, the last order, the respondent of it took time to file.
In fact, the affidavits were made ready, it has been sent for vetting. So at least can another 2 weeks time may be granted, also the officer will come and sign it. Because there was a change of guard for which some extra time has been taken with regard to filing.
Okay. Both sides are represented. Mr. S. Barwar and the comment advocate has submitted that he has prepared the affidavit in opposition for the respondent number 4, and has been sent for vetting.
Last order.
He prays for and is granted further 2 weeks time to file this same. Just after 2 weeks. How much? 2 weeks you
2
wanted?
weeks is enough.
Okay.
The date may be given.
Date,
Otherwise, my lord,
before this vacation, I am finding it very difficult. What is the matter about?
my lord, cancellation of the license, my lord, the beef shop, my lord. Exponent.
Okay, give a date after 2 weeks.
23/6.
36 my lord, same, my lord.
It is the same.
Same.
Okay. Okay.
Publish.
37.
Okay.
Yes,
Your Lordship, the engaged counsel is on legs in some other court. If any can the matter be taken up just in time.
okay. This after a week as paid for by Land Council for the petitioner. Both sides are represented.
The petitioner, in fact, lordship doesn't have any merit in this case. They were challenging the registration.
Okay, sir, senior is not there. There are 2 matters I asked to be upgraded.
Those matters, that mentioned 76 and 77 arbitration appointment last time, Malok, they had taken time points.
I don't know, 1 or 2 matters. Which matters have been upgraded?
76 and 77. 76 and 77.
No, there are other matters also.
Lordship.
2 or 3 matters. Huh? 41.
My lord, is this petition, my lord, I am appearing as a petitioner in person, my lord.
Yes.
My lord, what has happened, my lord, e-challan had been issued in my name, my lord. A traffic violation challan, my lord. And that challan is under challenge, my lord. My lord, notice had been issued in this case, my lord. Sorry. Notice had been issued, my lord, with the direction to file a detailed affidavit long back, my lord, notice had been issued. And my lord, 1/2/2023, But till date, my lord, there is no response from the, my lord, authorities, my lord.
No, you see, this writ petition will be misconceived. The fact is that once a traffic challan is issued,
My lord,
then you have got two options. Number one, to pay the fine,
my lord.
or number two, to contest the matter before the trial court. How can a writ petition
No, my
be
lord, writ petition is
entertained?
maintainable, my lord, and such type of writ petition has been adjudicated, my lord, I will satisfy my lord. My lord. On other date, my lord, maybe please to fix, my lord, maintainability, I can satisfy, my lord.
In a writ petition?
My lord, yes, my lord, writ petition has been filed, challan has been issued, my lord, and lord, maybe. please to-
I'll tell you a small story. I don't know whether I can get it here or not.
My lord,
You have, who's for the transport department? You are there.
my lord.
Yes, you just listen to me carefully. One of my friends, he went to visit a foreign country, I won't say where.
My lord.
He got a traffic challan for, sorry, I can say the name, it's for Switzerland. He was given a traffic challan. Some fine was deducted. There is online deductions there. It was deducted, he challenged it. So on challenge being made, the authorities after 4 or 5 days provided him with photographs of the traffic violations which he did. And the fine was 250 Swiss francs. And because of this service which they gave to provide him with photographs of the overspeeding, he was charged 500 Swiss francs.
My lord.
He said that being an Indian was a disadvantage there
My lord.
because he was accustomed to our court systems and challenged it. And the authorities within some time gave him that.
Now, my lord, here in this case, my lord, the complete.
Okay, we'll take it as another day because
My lord.
I am privacy.
My lord, they can file an affidavit, my lord, and after a week or 2 weeks, my lord, can be taken up.
Because you see, it come to page 45.
My lord.
In 45, they have not even given their latitude and longitude.
Yes, yes, my lord.
There is 00 for some error, I don't know.
Nothing is
The
there. my
speed
lord.
is 74 km per hour.
That is they have said it was 70 and I was driving at 74 minutes. It is their statement. my lord.
No, 74 km was the speed.
Yes, yes, my lord.
At a distance of 41 meters.
My lord.
And this what you call the machines are quite what you call effective.
Interceptor.
If you want a demonstration, we can have it here because I've seen those machines working.
My lord. These are, my lord, on that day, I am admitting, my lord, I was traveling from Guwahati to Soigaon, my lord. And the location which they have said, there is so much traffic, my lord, even at 40, even, my lord, it is difficult to drive, my lord. And, my lord, the manner in which the challans are being issued all over the state, my lord, the requirement of the rule is not been followed, my lord. I have, my lord, gone through the entire rule that how it is required to be issued. Nothing has been done, my lord.
There were two lawyers in this court.
My lord.
Some people may be knowing the story. One is still practicing, one is left the world.
My lord.
When they used to drive, people would when they jump out of their car because they were so I think realized.
My lord.
They were such a what you call they were so fond of speed.
Oh, my lord.
In the what do you call it, in the private conversations, people say that they were above those movies. What do you call? What is that movie series?
Fast and Furious.
Fast and Furious. List on and give it next another day. We'll give it a date. Both such a represented, your prosecutor and matter could not be taken up to the list on so. We'll give a date.
76.
All right.
The 676, why not we fix it because they have to take instructions. Now, it's an arbitration appointment of arbitrator.
Who's there?
We have filed out Vakalatnama today.
Oh, okay.
Can it be on 12th or after 20?
We'll choose a date, the court master will give a date.
Lordship.
What says it represented? On the pair made by Mr. K. Pathak, counsel for
respond number one.
correspondent number one.
One.
Time is granted to file affidavit.
No, Your Lordship. I'll only.
Time is granted to obey the instructions, address the court, list on. The court master will fix a
Very
date after some time. Yes, any other matter, because I have to rise.
Number 50, can it be taken up on 14th, Lordship?
Just allow some time after I rise to the court master, one by one he'll take it up. Any interim orders to be extended, please tell it to him. So Goswami, you wanted to say something, you stopped?
One tender motions 49. It was pending. Urgency is there, stage operating.
49,
48, 49.
48, 49. Give a
Possible
date,
tomorrow.
short date. Tomorrow it may not be taken up.
Small matter.
Court master will give the date. Give a short date in 48, 49.
On a hearing date, Lordship. On a hearing date. Notice may be issued. We'll take
48,
it from the
49.
court master, Lordship, on a hearing.
Okay, okay. Yes,
Item of 52,
yes.
382 days, 382.
Oh, bail application. Okay, I forgot that. Nobody told me. Bail matter. Give a short date.
52.
Give it tomorrow. Bail application.
Your may I praise your honor, Lordship, item 80 of supplementary list, I have urgency in that regard. It's a contempt matter. Lordship, today it has been listed, but today also it could not be taken up. So kindly, if Lordship fixes it day after tomorrow.
Okay. Okay, 80 day after tomorrow. Okay.
Highly blessed.
Okay, other matters, court master will give a date. Just give him some time, one by one, we'll take care of it. Yes.
My lord, item 64, notice may be issued, my lord.
No, I'll not jump and pass orders. That will be improper.
My lord, this is,
Court master will give a date. We'll fix it on the day.
even when notice may be issued, my lord, motion contempt, my lord. Notice has not been issued yet. Recently,
Item number?
64, my.
64.
Today is the first listing, my lord.
You get it day after tomorrow. I don't have anything. The day after tomorrow, I'll pass on this.
Lordship, in item number 67.
Yes.
The only difficulty is that in the read petition, it was for instruction, initially it was for instruction, for consideration of the interim order, because my factory has been closed. So thereafter, I have filed a miss case for praying for the same stay. And that, let me short date, I pray for a short date, day after tomorrow, if possible.
Okay.
Much.